So, dear participants, I will kindly ask you to take your seats because we are starting our panel. And I will ask the directors to start with a video that is going to be shown now. Thank you very much. The wrongs that we seek to condemn and punish were so calculated, were so malignant, were so devastating that civilization cannot ignore because it cannot survive their being repeated. This is the opening statement of Robert H. Jackson before the Nuremberg trial. My name is Gurgen Petrosyan. I'm coming from Nuremberg. I'm a senior officer for International Nuremberg Principles Academy. And the mandate that we have in Nuremberg at the Palace of Justice is to spread the principles, the outcome of Nuremberg judgment. No impunity for international crimes, no immunity for head of states, fair trials for accused persons before international trials, and of course, just following the orders does not relieve the person from liability. I would also like to thank the organizers for having this important conference in these challenging times that we're experiencing today. We have different conflicts, different hot places in the world, unfortunately, today, which somehow try to change the legacy that was put after the Second World War. Yesterday, we had very important topics discussing together, like what is the role of the small countries in international law, in the whole this legal framework. We have discussed together what are the risks, how to prevent the risks of genocide happening all over the world and again and again. We have spoken also together about hate speech, the role of the hate speech, and this is, in my opinion, is one of the crucial moments where the risks of genocides are starting. Because if we go back to the Second World War, or even to the First World War, the wars, as mentioned by our panelists yesterday, means a lot. Like Untermensch, like subhuman or dehumanizing the people, is one of these core steps towards to genocide. Today, with our first panel, I'm very happy to have here distinguished guests, panelists, speaking today on different angles, how to prevent these genocides happening. Unfortunately, Mirza Dinay, he had to be here, but because of the weather conditions and the fog, he arrived in Tiflis. So I hope he can join us today a little bit earlier by video call. And the topics that we are going to discuss together will focus on international organizations, regional, sub-regional, national, and local actors. What are their roles in preventing genocide? How we are going to do this panel? So each panelist will have 10 minutes, and I will be very strict with the time. And in order to have a little bit more time for engaging with the public on these crucial topics. And without further ado, I would like to present our first panelist, Ms. Katharina Bomberger. She is Director General, International Commission on Missing Persons. She has over 20 years experience, and she has dedicated her whole career for international relations, human rights, politics, and conflict prevention. So, with this, Ms. Bomberger, I will give you the floor to you to start your statement, please.
Good morning, everyone. Very nice to see all of you, and really thank you for a tremendous, wonderful set of meetings. It's been fantastic, and many of the presentations that have gone before me have been really incredible. So I want to commend all of you for very fascinating presentations that you gave. This is actually the first time I've been at a genocide conference, which is very strange, given what I do. And I think part of the reason for this is that the issue of missing persons itself probably appears to all of you to be a very niche issue. What is this issue? And how does it apply, and how can we attach it to the issue of genocide? So as genocide scholars, as people that think about this issue, I really want you to reflect on this, and please invite us continuously to your conferences, because I think there's a lot to learn. And I think it's clear why this issue is important, obviously. When you're dealing with mass atrocities, mass crimes that take place, and particularly genocide, many of the individuals that we're looking at were disappeared. They were killed, they were executed. Their bodies were hidden, for example, in series of mass grave sites or clandestine sites. We call them missing persons because their fate is unknown. So let me tell you a little bit about ICMP, or the International Commission on Missing Persons, because you've probably never heard of it. So the International Commission on Missing Persons, and I'm looking here at my colleague from Slovenia, was initially created in 1996 to address the conflicts that took place in the Western Balkans, in the former Yugoslavia. And I have many colleagues here from ICTY, and in fact, Matthias Hellman and I were discussing, because we worked very closely together, what on earth could we possibly add to what's already been said during this conference. But I'll try to do that. So we were created in 1996 to address the conflicts that took place there. 40,000 people went missing as a consequence of those conflicts, of which about 8,000 missing persons were related to the Srebrenica genocide. And that conflict resulted in mass atrocities, also a genocide, and we learned a lot as a consequence of this. So my discussion today will be about how to document mass atrocities, how to document a genocide, and how to do so in a manner that that evidence can be provided to an international court so that perpetrators are held to account. And perhaps these measures now, which are very new, these efforts to document large-scale atrocities and genocides, could lead to prevention. And I think this is something to think about, and something that has been addressed in the context of this conflict. But recent conflicts, and here I turn to Ferdinand, who yesterday said, and rightly so, according to the Norwegian Peace and Research Institute, we are now going through a period where we have the highest number of conflicts since 1946. And I can say that the numbers of missing persons as a consequence of this are on the rise, including Armenia, where we're just in the process now of completing an assessment report, which we have given to the government of Armenia. And part of my work here is to work with Armenia now to implement the measures in this particular document, which also requires documentation of crimes. Also, due to global warming, there's an increase in the number of missing persons, and also, as a consequence of all of these things, there's a rise in the number of migrants. So we're going through a very difficult period, and I will talk about migration and the atrocities related to that. But let me go back a little bit to the former Yugoslavia and describe the work that we did very quickly. So about 8,000 Muslim men and boys were killed in a matter of days. I think possibly all of you know the story, but I don't know to what extent you understand what happened. But they were executed in a matter of 3 days. Their bodies were hidden in mass graves strewn across eastern Bosnia. The perpetrators responsible for these crimes went back to the original crime scenes, removed the bodies using heavy machinery, and buried them in a series of mass graves across eastern Bosnia. We call them secondary grave sites, okay? So when we finally came with ICTY to see the atrocities that were committed, I mean, I was going to show a picture. I thought maybe this audience, you know, if anyone could take it, you could, but I decided not to. But it was extreme. I mean, it's a picture of hell. So the bodies themselves were buried on top of other bodies. Okay, so they were bulldozed from one location, put onto another. So using any other method than DNA identifications was not possible. So we made a decision in 1999 as an organization to use DNA testing to identify these victims. Now, we didn't know if it would work, and this is part of documenting crimes, and now today you wouldn't think twice, but we'll talk about that, about using DNA. But we made a decision to do so, and when we did, we didn't know if it would work. It worked beyond our wildest dreams. Not only were we able to identify the victims, but we were able to uncover a genocide. We were able to prove that the perpetrators not only killed 8,000 Muslim men and boys, but that they tried to cover up this evidence, thinking that it would never be found again. But using DNA required a methodical process where you collect data, not just, you're not only investigating people one at a time, but you're scaling up to address the level of mass atrocity. So that means collecting reference samples, meaning genetic reference samples, from every single family that has a missing person. So in the context of the former Yugoslavia, 40,000 persons went missing, so we had to try to collect over 120,000 reference samples. This means working very carefully with the victims, educating them about their rights and the use of DNA, and then matching that evidence to the bodies found in mass graves. So that happened. So for one body, you needed at least 7 DNA match reports to piece together in a Frankenstein-like way the bodies that were found in these mass grave sites. And eventually we ended up with ICTY providing this evidence in over 35 criminal trials, including the Mladic and Karadzic trials. I live in The Hague. I bicycle past the prison now and feel very proud, and proud of many of you here that worked on these efforts, that the Karadzic is now in jail, Mladic is in jail. So this was an extensive effort that required a methodical use of DNA. But let me now fast forward to more recent conflicts, and also with regard to Armenia, because this is exactly what we're going to try to do here, including what happened in 2020. So this effort will require a large-scale methodical process. We've been working in Iraq, and I'm sorry that the Yazidi gentleman cannot be here. We did exactly the same thing after ISIS crimes together with the state authorities. So let me emphasize also that the state is responsible for locating missing persons and investigating their disappearances. But this does not often happen because there is no political will, either on the part of the state or the international community. So political will is absolutely required if you're going to use methodical methods to document crime scenes. So we're doing this in the case of Yazidi missing because we're able to work with the Iraqi government. So as soon as these crimes happened, we were able to go to Kocho village and other places and apply the same methodology. With regard to Syria, which is now very much on our minds, we are attempting to do the same thing. Now, of course, the Assad regime had no interest in a sustainable process to find missing persons and investigate their crimes. But now we may have an opportunity to do so. So our work prior to this, since 2016, has focused on collecting evidence to lay the groundwork for a future process, which may happen now. So to date, we've collected data from over 80,000 families of the missing who've reported 30,000 people missing. So again, the methodology of collecting data, documenting sites. So we're using OSINT technologies, we're using satellite imagery. We're working together with families of the missing who have a lot of data. We've created data partnerships. We've created data governance groups to go over to be able to govern that data and ensure that it's being used in line with best practice. And this can be difficult when you're dealing with traumatized victims. But now I think there's a time now where we have issued a number of press releases to ensure that evidence is not destroyed. And we can see that happening right now as prisons are being opened, prisoners are being released, Documents are everywhere. The news media is already out there at mass grave sites destroying evidence as they did with Bucha. Speaking of Bucha, we're also working in Ukraine. And here it's a very interesting situation because on the one hand, you have an active conflict, and on the other hand, you have a concerted effort to investigate criminal activity. So we were invited by the prosecutor's office just following the beginning of the conflict after the invasion to work with the prosecutor's office now to investigate missing persons cases to a level where that evidence can be provided to an international court. Now that's very, very important. So we're helping them do this, but the scale is huge. So what Ukraine is doing, what Armenia has been doing, what most governments do, is they investigate missing persons cases as they would before the scale exceeded the capability of doing this on a mass level, one by one. So police are conducting investigations. There's one atrocity crime. I think you may remember, for example, in Ukraine, there was a tank that encountered a civilian car. The civilians came out of the car, put their hands up, and then the tank killed them. So the Ukrainian prosecutor's office is now dealing with that particular crime one by one. But what we recommend when you're dealing with a scale of atrocities that are occurring in Ukraine or Syria is scaling up. So that means the number of prosecutors, judges, forensic experts within the state have to be scaled up. So another component of our work is also to help that state scale up, to create the requisite institutions. Armenia has one, for example, that we're working with, to work with families of the missing so that they understand, to use advanced data systems so that there's proper chain of custody. Because when you're using DNA, you're using irrefutable evidence of identity, scientific evidence, which you then need to link back to the crime scene. So I'll conclude now because I see my 10 minutes is over. There's a lot to talk about here, but just in conclusion, there's a good side to all of this, and I think we're optimists here. It is very difficult to, whether the jury is out, whether this documentation, whether providing evidence in court will succeed in preventing future genocides. But I would argue that maybe it already has in some cases, for example, in the former Yugoslavia. So that effort now, which is very new in the world to document these sites, must continue because we've made huge advancements. There have been advancements in war, and yes, there are more wars, but at the same time, the good news is that there have been huge advances in documenting war crimes to provide irrefutable evidence. We just need to make sure that criminal courts, international courts succeed, and political will.
Fantastic. Thank you very much, Ms. Bomberger. And of course, thank you very much for your work that you are doing, because as you mentioned, documentation is one of the core elements in order to identify if there is of course these are the puzzles that you need to collect in order to prove there is a dolus specialis, for example, in case of genocide. So documenting the evidence is one of the important steps in also prosecuting the genocides. So now we are moving to the next panelist, and he sent us a video message. This is Bernard Duhaime. He's a special rapporteur on truth, justice and reparation and guarantees of non-recurrence. He is a full professor of international law at the Faculty of Law of University of Quebec in Montreal. So now I will kindly ask the director to show us the video.
Good afternoon. I want to express my gratitude to the government of the Republic of Armenia for bringing us together once again in the 5th Global Forum Against the Crime of Genocide. The relevance of this annual platform devoted to exploring key challenges in preventing genocide and other atrocity crimes cannot be overstated. I congratulate the government, the Office of the Special Advisor of the UN Secretary General on the Prevention of Genocide, the International Association of Genocide Scholars, and the GAMAAC for their role in convening today's forum. It's an honor to address you today to discuss the topic of strengthening the effectiveness of international mechanisms for early warning and the early responses to the risk of genocide and other atrocity crimes from the perspective of the work and practice of the mandate of the Special Rapporteur on the promotion of truth, justice, reparation, guarantees of non-recurrence, which I hold since the 1st of May 2024. As many of you are aware, prevention of mass atrocities is part and parcel of the work of this mandate. The Human Rights Council Resolution 54/8 requests the Special Rapporteur to explore further the contribution of transitional justice to the prevention of gross violations of human rights and serious violations of international humanitarian law, including genocide, war crimes, ethnic cleansing, and crimes against humanity, and their records. The mandate has devoted a full report and a study prepared jointly with the Special Advisor of the UN Secretary General on the Prevention of Genocide to the issue of the prevention of gross human rights violations and atrocity crimes. It also presented 3 reports on the role of transitional justice measures, such as guarantees of non-recurrence, security sector reform, and memorialization, in preventing such violations. In addition, the mandate has advocated for the adoption of preventive tools through country visit reports, communications sent to states and other stakeholders, and the provision of technical cooperation. In 2015, the former Special Rapporteur, Pablo de Greiff, presented to the Human Rights Council and to the General Assembly 2 reports on the notion of guarantees of non-recurrence, where he argued that this notion is inherently forward-looking and preventive. He reasoned that guarantees of non-recurrence refers primarily to a function, and that function is prevention. In his report on guarantees of non-recurrence, the Special Rapporteur called for a more focused attention to the challenges arising as a result of weak governance and the non-satisfaction of human rights, particularly the right of marginalized groups and individuals, to improve outcomes in the field of prevention and early responses. He also noted the role of education and history teaching in transitional justice contexts as a powerful guarantees of non-recurrence and prevention tool. He called upon states to conceive educational reforms, cultural interventions, including memorialization, and archives as part of their non-recurrence and prevention agenda. Education and cultural initiatives, including those involving the youth, can play an important role in identifying and timely responding to both entrenched and emerging societal grievances and challenges. In his report on security sector reform, Mr. de Greiff focused his analysis on the preventive exponential potential of measures associated with the reform of the security sector, including the vetting of security institutions, the reform of internal regulation, and the strengthening of oversight mechanisms. The latter, in particular, can also play an important role in providing early responses to emerging security challenges. My predecessor, Fabian Salvioli, devoted a report to examining the role of memorialization in transitional justice processes and their preventive role, where he highlights the need for vigorous, active, and multidimensional memory policies in order to respond adequately to gross human rights violations and, importantly, to prevent their recurrence. He noted that in addressing past violations, memorialization processes seek to, first, shed light on past preventions, second, address the challenges of the present, and third, prepare for the future. Regarding its forward-looking function, memorialization can help preventing violence through education, awareness raising, and the promotion of a culture of peace. He argued that memory processes can help promote commitment to a democratic society, encourage open debates on the representation of the past, and allow entrenched challenges to be identified and responded to adequately and timely. By helping society move towards a culture of peace and mutual recognition, memorialization processes can help societies reconcile with their past and prevent recurring violence. Besides these 3 aspects, it is evident that the other pillars of the mandate, truth, justice, and reparations, also play a strong preventive role. Accountability for past violations can play a strong deterrent role and restore society's trust in its institutions, which can help prevent the recurrence of mass violence. Truth seeking and truth telling help societies understand the structures and responsibilities that enabled past violations and design the foundations for a future where such conditions are identified, addressed, outlawed, and thus prevented. And of course, acknowledging the harm inflicted on victims and addressing their grievances through full reparation allows them and society as a whole to heal and move forward on a sustainable path towards peace. In 2018, a joint study was presented to the Human Rights Council on the contribution of transitional justice to the prevention of gross violations and abuses of human rights and serious violations of international humanitarian law, including genocide, war crimes, ethnic cleansing, and crimes against humanity, as well as their recurrence. It was drafted by the former Special Rapporteur Pablo de Grief and the former Special Advisor to the Secretary General on the Prevention of Genocide, Adama Dieng, pursuant to Human Rights Council Resolution 33/19. The report identifies the greatest obstacles to prevention as weak commitments, insufficient investment in prevention measures, late intervention, and the fragmentation of knowledge and expertise. These experts proposed the adoption of a framework approach that would give substantive content to broadening and upstream movement of the prevention work. To develop such approach, they urged the strengthening of 4 areas of intervention in the field of transitional justice that can play a crucial role in preventing and responding timely to the risk of violence where it arises. These are, firstly, institutional reforms, such as judicial reform, security sector reform, etc. 2. Legislative reforms, such as constitutional reform, criminal law reforms, etc. 3. Initiatives in the institutional sphere, strengthening governance institution and civil society institutions. And 4th, interventions in the domain of culture and personal dispositions, history education, culture initiatives, and religion. At the international level, the mandate of the Special Rapporteur has pointed to the institutional and functional fragmentation of practices and knowledge in the field of guarantees of non-recurrence and prevention as one of the main challenges hampering its untapped potential. In his report, has developed a set of observations and recommendations which are relevant to the topic addressed today, and has regularly engaged with states and non-state actors to discuss and provide guidance on areas which have the potential to prevent the recurrence of mass violations, or conversely, if not addressed in a timely manner, to set the background for their repetition. I would like to express my readiness to accompany state authorities and civil society in their efforts to design and implement effective measures for the prevention and timely response to the risk of gross violations of human rights and serious violations of international humanitarian law, including atrocity crimes, through transitional justice frameworks that fully comply with international human rights standards. I would like to conclude thanking once again the organizers for the opportunity to share the views of the mandate on this very crucial issue, and to remain available for future discussions and avenues for collaboration. Thank you.
We thank Mr. Bernard Tuhem also for his work, and one of the maybe important keywords that we need to keep in mind is intervention, especially at the earlier stage where we see already that the steps are developing in direction of genocide, and intervention with the judicial system, internal judicial system, and also with the social, with the civil society. And I think we will still come to that point with the civil society a little more in detail, what is the role of the civil society and different actors. But now we move to Mr. Lord Mark McInnes. He's a Lord and member of the House of the Lords, and he has been a member since 2016 and have been served as a Prime Minister's Special Advisor on constitutional matters. Now we will have a little bit different angle from the legislator perspective, what exactly has to be done. So, Mr. Lord McInnes, the floor is yours. Thank you very much.
Thank you very much. I would like to begin my remarks just by thanking the Armenian government for being able to host and inviting me along to join all of you yesterday and today. I think there are a few other countries in the world where concern and remembrance of genocide is more important than in Armenia, and very sadly it is an ongoing concern rather than one of just historical record. I'm also privileged to be the Vice Chairman of the Armenian Friendship Group in the United Kingdom Parliament, and I'm very pleased to bring along the greetings of my colleagues we met last week, and everyone is very much looking forward to me reporting back on the conference and a discussion of the necessity and improvement of early intervention in genocide prevention. So, how did I happen to take an interest in where we are today? First of all, I had a great personal interest in the Armenian genocide for a very long time. That led to a wider interest in genocide prevention and humanitarian issues, and I quickly came to the view that being an enthusiastic amateur wasn't always the best place to come from, and so I completed a master's a couple of years ago during COVID in humanitarianism and conflict prevention. So hopefully that's equipped me in Parliament to be able to properly recognise the issues that we all face in being able to properly intervene early and stop genocide from taking place. And so I arrived in the very odd British situation of being appointed to the House of Lords in 2016 and being interested in humanitarianism. And someone said to me when I arrived, what a great opportunity, focus on the issues that you're interested in. And so I, at that point, became very engaged in the issues around in Iraq, around the mass displacement of minorities within Iraq, and the steps that were being taken to try and alleviate that position and stop genocide being carried out. and we were able to get some funding to help in those early interventions that were required to bring communities together and, as we've just heard, ensure the dialogue took place that's required to stop hate speech, othering, and then the next steps, as we know only too well, of further genocide. But what struck me at that point was already there was, and is, a hierarchy of concern. So in Parliament, there are people who have specific interests. There are other groups who have specific interests. And while individuals may raise points, unless there is a consensus and interest in a particular issue, the chances of getting government action, either at an individual state level or at a multilateral level, become much more difficult. And so I was engaged with a small group of people in terms of issues in Iraq, and then with the Syrian civil war became engaged with a much larger group of people in terms of the Syrian crisis. And what became clear in that was, with the very sad death and washing up on the Greek beach of Alun Kurdi, the child who made the headlines and front pages of every newspaper across the world. Until that happened, there was not that consensus or popular interest in the subject that then allowed legislation to follow that allowed a Syrian resettlement scheme. And I think why that's very important when discussing early intervention in genocide and stopping genocide is how important that creation of a popular view and popular opinion is in country to be able to overcome many of the political issues that we discussed yesterday. And then along came Nagorno-Karabakh, and myself, Baroness Cox, who will be known to many here in Armenia, and other legislators would raise the issues, raise the siege, raise the inevitability of what was going to happen and a mass displacement on genocidal grounds. And the general attitude was, that's all very difficult. Clearly, the Azeris and the Armenians do not have a good relationship, and that is a situation that we want to avoid. And that fundamentally, ladies and gentlemen, is the biggest issue that we face in terms of individual state policies, and that feeding through to multilateral concerns. That feeling that these are internal issues or they are between countries who have a very long tradition and other countries not wanting to get involved. And we discussed yesterday in a historical context what would have happened if the Armenian genocide happened now. And I think very sadly, we all came to a consensus here that not a lot would be different. But actually, I think it's worse. Because looking back at that period from the 1890s through to 1921, if you're to look at parliamentary debates, if you're to look at civil society, in much of Europe, there was popular mobilization around the fate and concern of Armenians in Western Turkey, Eastern Turkey rather. That, I'm afraid, is not true for so many of the causes that we feel strongly about and the genocidal conditions that we are trying to avoid. So that did make me reflect then on the importance of that popular, once again, that popular will leading through to a political will. And yesterday, I was very struck when Elizabeth, when moderating one of the panels yesterday, said, we are united in solidarity, but solidarity is the bare minimum. And to be able, I think, to convert that solidarity into action requires the political will, the overcoming the issues that were raised yesterday by Professor O'Brien, Professor de Varane, and Dr. Varndian. Those challenges are not, importantly, just about processes and structures. The physics of genocidal prevention and early intervention are really important. We heard yesterday how important the work of the Special Advisor is in making sure that the Secretary-General is aware of concerns at as early a stage as possible. Evelina raised the issue in the UK that at the moment there is not a regular reporting mechanism to identify the need for early intervention to avoid genocide. Again, that's very important, but the best processes can be in place at a multilateral level. But if individual states do not have the will and popular support to overcome those, and that's not even talking about the geopolitical issues and the self-interest that all states do have, if they do not have that popular will, they are not going to act. So if the structures are the physics, I want to talk just now about the chemistry, because the chemistry is about the creation of that popular support for genocide intervention at a very early stage. My own professional background is in a pollster, as a pollster. So I spend a lot of time across Europe, the UK, Australia, listening to focus groups, carrying out quantitative as well as qualitative research. And when people discuss foreign affairs, what do they say? First of all, the good news is they are still committed to humanitarianism. People do understand the importance of intervention, and they do understand the importance of looking after fellow members of the human race. However, fundamentally, in a world that's become more parochial, cost of living, and all the other concerns that people have, they are concerned about the implications of their country taking too strong a stance at an early stage in intervention against genocide or to stop mass displacement of people. So what we need to do, I would posit, is create that popular opinion and salience of humanitarian issues to ensure that people understand the importance of early intervention. And the crucial point is that those people I speak to across the global north in particular do no longer trust politicians, they no longer trust institutions, and therefore, ladies and gentlemen, the people they do trust are experts. And I think all too often we underestimate in the formation of the public discourse around early intervention the importance of academics and people who work for NGOs in engaging with civil society in countries that intervention is expected for, to create that popular consensus in favour of intervention. Because that popular consensus, going back to my Syrian example, was only created when a child was washed up on a beach and it was on the front page of every newspaper. Now we're in a position where genocidal prevention only becomes a popular consensus after the genocide has taken place. If we're going to turn that around, it's going to rely on experts properly engaging with mass mobilisation to be able to create that popular consensus. Because, in conclusion, politicians are cowards. They are people who have particular interests, and their biggest concern is always electoral outcomes. And what we have to do is ensure there is an understanding that there is a popular will in favour of early intervention to stop genocide, because by doing so, we clear the ladder all the way up to the UN and ensure that intervention does actually happen. Thank you very much.
Thank you very much, Lord McInnes. I think these are very important notes about the role of defining the public opinion. However, the practice often shows that the voices of the NGOs sometimes do not reach the politicians. Practically, of course, theoretically it's important to consider the NGO voices, but really in the practice, as you all correctly also mentioned, geopolitics play also a huge role there. So I have some good news because our next panelist, Mr. Mirza Dinay, is now in our Zoom call. So I will kindly ask the director to show us the Zoom session where he's apparently following our session now. And I hope Mr. Dinay will have the chance still to visit Armenia. He's a co-founder and director of the Air Bridge Iraq, and he is an Aurora Prize laureate for Awakening Humanity 2019. And he is a Yazidi human rights activist. So I would kindly ask the director to show us the Zoom call, if possible. So we can give the floor to Mr. Dinay. I hope he's following. What? Should we go to the next panelist? So he's not online. All right. So my news were fake news. Then we'll move to our next panelist, to Dr. Andrew Forder. He's a commissioner, Irish Human Rights and Equality Commission, at the Irish Human Rights and Equality Commission, and he is an assistant professor, and he has a huge experience, especially from the Council of Europe. So now we'll delve a little bit into the Council of Europe perspective, how this institution can help in identifying the risk and also combating the risk of genocide. And Dr. Forder, the floor is yours.
Thank you very much, Chair. Colleagues, great pleasure and profound privilege to be here with you this morning. I want to just echo the plaudits to the government of Armenia, the Ministry of Foreign Affairs, for the leadership that they've shown in not just convening this event, but being steadfast, tireless ambassadors and champions for justice and accountability for the most egregious crimes. So really hearty congratulations and strong encouragement to continue. We've naturally heard a lot about the UN system over the last, over the course of yesterday and a bit this morning. Closer. I'm going to change tack a little bit and focus on the European system, because I'm strongly of the view that the regional mechanisms can play a very important role when it comes to early warning and potential conflict prevention. Now, notwithstanding enormous challenges that the Council of Europe has faced, I'm actually an optimist, and I think that there's a lot that can be done to strengthen the system. So just as a reminder to people, the Council of Europe is the oldest intergovernmental organisation in Europe with 46 member states. It has an elaborate framework of international law treaties, 200 plus standards, a key covering all kinds of areas from torture prevention to culture, education, anti-racism, and so on and so forth. It's a unique system, really, and it operates on the basis of standard setting, monitoring or fact-finding, as we discussed yesterday, and cooperation to try to work with the states to actually practically improve the situation on the ground for citizens. Importantly, genocide does not form part of the vernacular in the Council of Europe. That is not to say that genocide is not relevant. Of course it is. There is recommendations from the European Commission on Racism and Intolerance recognizing that hate speech and intolerance is part of that slippery slope to atrocity crimes, including genocide. But genocide is taken, in a sense, the convention is taken as read. There are, however, other major treaties that amplify, that support the rights that are relevant to people that are the first to be violated when it comes to processes of genocide. And the first, of course, is the European Convention on Human Rights, Article 2, the right to life, and Article 3, the prohibition of torture being the prominent ones. Complementing that, then, the European Convention for the Prevention of Torture and Cruel, Inhuman, and Degrading Treatment or Punishment builds on the Article 3 prohibition of torture. But other treaties that are relevant include the Framework Convention for the Protection of National Minorities, because as has been very well articulated already, it is often those that are marginalised, those that are othered in society, national minorities or vulnerable groups that often find themselves at the blunt end of these processes that can lead to serious violations. The Charter on Regional Minority Languages, similarly, which is very strongly focused on identity, the sense of person and place and heritage, those things that what it means to be a particular part of a particular group is also extremely relevant. And these are not abstract, voluntary, legal commitments. It's very important to understand. Many of them are built in to the accession requirements for the Council of Europe. You cannot be a member of the Council of Europe unless you ratify the Convention for Human Rights, obviously, but the Convention for the Prevention of Torture and the Framework Convention now for protection of national minorities. It is now well established that these are requirements for membership. To try to ensure that they are applied in practice, of course, of the Council of Europe. It's in principle about engaging early, determining the important to recognise that it very much is around trying to identify where there are opportunities to progress, where there are in terms of highlighting current violations. Never was it more demonstrated, I think, than in the situation of Northern Karabakh from 2020 right up until 2023, when we saw the calls by the Parliamentary Assembly to urgently focus on what is happening in a very well predetermined, planned process of repression that led ultimately to the mass displacement of more than 100,000 people from Northern Karabakh in a manner that is consistent, I think, with the genocide. But obviously we know that the follow-up was desperately insufficient. And the last monitoring mechanism, and you might be puzzled to hear me say this, is the European Court of Human Rights. Yes, the court, of course, is a judicial instance, but the court can do on-site monitoring visits. As part of the Rule 39 procedure, there is nothing to stop the court from actually going on site and verifying facts. Now, we have interim measures that have been applied, and there's a question, of course, over how effective they have been. This leads me now to the weaknesses, because it's very important that we're clear about the weaknesses, and there are many. I would say three in particular. One is the inconsistency of reactions. The second is the issue of access to conflict-affected territories by monitoring mechanisms and others. And the third, of course, is the follow-up issue. In relation to action, or inconsistent action, I would point to the situation of Crimea in 2014, when we had an egregious breach of international law, and the Committee of Ministers of the Council of Europe did not act, failed to act on the statute on the basis of the basic principles of international law, And failure to act emboldens the offender. We have to be completely clear about that. If the Council of Europe had acted decisively with Russia in 2014, I'm not saying it would have prevented entirely what has happened, but at least we would have been true to the values. It may have been served as a deterrent effect. What actually happened was nothing. There was an annual report at the end of 2014 from the Council of Europe Secretary General, which is quite shocking. No, it doesn't talk about the illegal annexation of Crimea. In fact, what it talks about is the fact that the Ukraine's problems didn't begin or end in Crimea. It's quite a staggering situation. So on the issue of access, monitoring mechanisms are also prevented routinely from accessing conflict-affected territories. This is a real problem in Transnistria, Northern Cyprus, of course, Nagorno-Karabakh, and when there is no adequate justification, there's still no action. It's just accepted as a fait accompli. Then when it comes to follow-up and the lack of follow-up, Nagorno-Karabakh was the most stark example, because this happened in real time and nobody can plead ignorance. Yet nothing of any meaning from the Committee of Ministers. No sanction, no declaration denouncing what Azerbaijan had done in Nagorno-Karabakh. So very, very profound deficiencies. But I said I'm an optimist. There are opportunities, I think. What we saw on the 16th of March 2022 was a decisive turning point for the Council of Europe. Russia was expelled from the Council of Europe. It was the first time in the history of the organisation that the relevant articles were triggered to the extent that a member state was expelled. This marked a profound change of direction. The Reykjavik Declaration, which followed shortly afterwards, has set the Council of Europe now on a post-peace trajectory, a trajectory where human rights, democracy and the rule of law are complemented and secured only by ensuring accountability for serious breaches of the statute. And this is very, very important. But what we now, and I invite you to look at, is a number of things that can still and should and must be done to strengthen the system. The first, and we heard a lot about the idea of political will, but I would urge you to consider the idea of normative will. And what I mean by normative will is normative will not as an antidote to political will, because of course these are political organizations. But the system that we have, which is in principle robust and includes a Secretary General that is not beholden to the whims of member states, that Secretary General and all of the apparatus that follows and flows from the Secretary General should be doing the job to the maximum extent that they can. The Secretary General can communicate in his or her weekly communication to the member states issues of core concern. He can or she can establish a special representative to investigate further, can engage with the monitoring mechanisms to ensure consistent engagement in terms of access and so on. Normative will, I think, is very, very important. The second issue is the presumption of access, because I think this is a really important thing. When a member state signs up to the Council of Europe and signs up to treaties, it is implicit in that they will accept a presumption of access on the part of monitoring bodies. And if they, for potentially well-founded reasons, wish to restrict that, that should be tabled at the Committee of Ministers and justified adequately. If it's not justified, there should be a follow-up. The third point is the question of sanctions reform. The Council of Europe Committee Ministers issued the ultimate sanction in Russia, but it did it with the lowest, or if you want to say it, highest possible threshold. A full-scale invasion based on openly genocidal intent. We need to think seriously about what is the sanctions possibilities. And sorry, just two last points. I know I'm over time. The last 2 points I would make is the question of resourcing. And this is something that cuts across all international human rights bodies, where they are on their knees. And that needs to be seriously thought about. And the final point I will make is the question of advocacy, and to not underestimate the role of civil society, national human rights institutions, and human rights defenders. Thank you very much.
Thank you very much. Indeed, thank you very much also for another time remembering us about the failure that happens and acknowledging that failure. I think we are at the stage that really we need to understand, or we need to really acknowledge the fact that at these challenging times, the international institutions are not really, are a little bit hesitant of moving things forward. But I think we'll come to that in more detail in the discussions. And also, thank you very much for numbering also the normative will. I think yesterday Francesca Albanese also mentioned that the principle of legality is also an obligation for the state, so in order to be compliant with international regulations and standards. So now we move forward to our next panelist, our distinguished panelist Sheila Pailan, a wonderful colleague of mine. She's an international criminal lawyer and war crimes investigator, human rights and gender expert, and she has a huge experience working with different international criminal tribunals, ICTR, ICTY, Khmer Rouge Tribunal. So we have a very experienced colleague in international criminal law field, and Sheila will delve mostly into the practice of actors, individual actors and social civil society. So Sheila Jan, the floor is yours.
Thank you. It's a real honor to be here. Unfortunately, I have a terrible cough, and I'll try to keep it under control, but I might cough, and I'll do it that way. That bio suggests that I might talk about international criminal justice and my experience there. I will a little bit, but in the sense that having done that for 12, 13 years in the courts, including with Judge Millard, who was one of my greatest mentors. When the Nagorno-Karabakh war in 2020 happened, it was an explosion in my brain where I realized, you know, at what point is all this work going to start meaning something? I know it means something, of course it does. Like, there's no doubt that the jurisprudence that we come up with and the war crimes that I have investigated in the Congo have led to some justice, but at what point does it start preventing? And so the more I thought about it, I've sort of turned away from pure international criminal law and become more of an activist and consider myself more of a human rights lawyer and activist. And I think when we think in the context of this current panel, some risk factors that we rarely talk about, but which I keep seeing more and more, are apathy and desensitization. These are factors that, if you think of the framework of an analysis for atrocity prevention that the Special Advisor on the Prevention of Genocide's office has come up with, they don't feature there, but it is one of those factors that contribute to perpetuating what we see as being an endless problem of never again, yet again and again. As another international actor, which goes all the way down to local actors, but those local actors are individuals. And when we talk about the international community, the endless times I heard calling on the international community to do this, that, or the other in the context of Nagorno-Karabakh and since then Gaza and what have you. Because, you know, I spent a very long time, basically as a piece of furniture in an office in a UN court, and not realizing that these calls were being made all along. I was part of one of the most functional parts of the UN when it comes to addressing these kinds of atrocities. But there are so many cases that fall through very large cracks. And so the international community, what is that? It's this nebulous abstract thing. It is a community of states. And what are states? They are comprised of people. A state is nothing without its people. It is not a state. It is terra nullius. And so, you know, when we call on the international community, we're calling on people, and we're basically calling on ourselves. I am the international community. I am part of that. So what am I doing? What is my part? Instead of pointing my finger to some abstract international community, I have to internalize this as me being an actor if I really care about preventing genocide and other atrocity crimes. And so, among other means, such as monitoring, reporting, conflict resolution, prevention, is serious activism. This is like, I mean, like really serious, like not just tweeting or writing. Sorry, my mouth is all of a sudden really dry. But serious activism. And I think I was really, really proud to be here during a very, very difficult time for my people, having spent all this time abroad. I mean, I was born outside of Armenia. But in the meantime, we see the levels of activism that really move or create movements in support of Ukraine and in support of the Palestinians. It's I think, the single, considering how long the Palestinians have been suffering, the level of activism we have seen of late is the game changer. It has been the game changer for Palestine. So if I were, I mean, I've been brainstorming this for a while, if I were to sort of have these sub-risk factors when it comes to apathy and desensitization, I would refer to conflict fatigue. There are so many conflicts, and so we tend to get tired of it, you know? And especially long-standing ones, which was the situation for Nagorno-Karabakh. It just doesn't get that kind of media attention anymore. So you have to be aware of this. It's not an excuse, it's an explanation, and so how do we fight it? The normalization of violence, there's just so much of it on TV that we become desensitized. So it doesn't have that alarming factor. I mean, seeing 120,000 people drive in cars to leave their ancestral homeland doesn't have the same impact as, you know, children being bombed under rubble. And so you think, well, that's not a crime. No, it is. It's just it's not as shocking anymore. And then competing global interests. This is where the conflicts we focus on will shift depending on what's more interesting or what's more, you know, economically or strategically important. Because I promise you, if we cared about Africa the way we care about the Middle East or Russia, you would be shocked at the numbers and the grotesque level of violence that persists there, and we just don't care because it's not important enough. So these are things that we as individuals have to be aware that we are part of the problem when we don't consider what are we paying attention to and how much attention are we paying to it. And always calling on the international community or someone else to fix it is not, I mean, I get it. We have mechanisms and we want them to be triggered. But this is why I'm so glad, at least, you know, all the presentations have been great, but I really thought I was going to be the rogue weirdo on this panel. But Lord McGuinness alluded to it, where political will is the will of the people. And so it needs to be, like, we need to remember the agency that we have to shape that and not be dulled into thinking that we're too naive if we think that we can make a difference. Of course we can. I was going to, I see like there's a timer and I thought I would be done by now, but I'm like not even halfway there. I want to bring something up. Yesterday there was a lot of doom and gloom about how bad the world is and how horrible the situation is. It's really bad when you look at it the way the news presents itself. But overall, over the history of mankind, the last 80 years have actually been, we have never been doing so good. The world is much more actually at peace than at war. There's much less extreme poverty. There's much less child mortality, less victims. I mean, there are more people on the planet, but when you think of it in percentages, the Human Rights Project, which is about as old as that time frame I'm giving you, is working. It works. It's just starting to crack. So what we're seeing now is not that it's worse than ever. We're actually better than ever. And this, I mean, just Google or ChatGPT it, I swear, I'm not lying, I didn't make it up. I'm as dark and stormy as everyone. But the data says that even plane crashes, like, it hasn't just diminished, it's plummeted. We are doing great. But it's like a nascent democracy, it's under threat, it's fragile, and you have to protect it. So one way that it's starting to crack, I really think, is the advent of apathy and desensitization. We're not paying attention. We're not doing what we need to do to make sure that authoritarianism doesn't continue to rise, and that we don't keep our leaders in check. Noam Chomsky, I'm going to read this part of it. Noam Chomsky, he's so amazing. He says always the right thing, but he said this about national interest and how it affects Palestine. Part of the tragedy of the Palestinians is that they have essentially no international support, for a good reason. They don't have wealth, they don't have power, so they don't have rights. He said it better than me. It's the way the world works. Your rights correspond to your power and your wealth. So the Palestinians, they may get statements of support, but no one's going to do much for them, especially when the US threatens anyone who might try to do something. We do not live in a society in which the public determines policy. The public's around, but basically disregarded unless they basically force themselves into the system by serious activism. We've reached this point. We have to take it to the next level. If we really care about preventing genocide, we can't just constantly say the same thing over and over again. We have to take it to the next level, and it will work. And I really think that there's the biggest missing piece is the level at which we reclaim our agency as members, individual members of the international community, to perpetuate and make that change. I have 45 seconds left. Am I going to use them? No, I'll stop there. Thank you.
Thank you very much, Yerevan. I think this is a very important point that you have mentioned, that all the actions that are being committed are not committed by the abstract entities. This international community is not abstract. There are individuals behind that. And either they are being committed wrongdoings or some other actions individuals are doing. And I think we need courageous people in international law, especially during these challenging times, to move something in a better position. And I want to bring two historical personalities of courageousness, because if we witness international crimes, we need also prosecutors who bring cases. We need courageous prosecutors who take action despite of this challenging situation, bring these cases before international or national tribunals. After the Nuremberg, after the Second World War, there was a German prosecutor, Fritz Bauer, who identified after the Nuremberg trials that the same persons were released and then they received the same positions. In the 60s, he started the Auschwitz process, the Frankfurt trials. In Argentina, we have Julio Stracera, who, despite of the challenging situation, also took the courage and started the prosecution. So we need these courageous individuals behind this international community. And history shows that sometimes we have them. Now we move to our final panelist, and I hope he is already in our Zoom call. And I will, as soon as I already read his biography, I will just give him the floor. Mr. Denai, please.
Thank you, Gorgen. I'm so sorry that I couldn't arrive in the correct time because of the weather, but I was insisted to participate in this very interesting meeting and this very interesting forum. Maybe at least to deliver a voice of the victim shouldn't be also the victims from the past 10 years, but all the victims. And my concern, you have mentioned some point at the beginning, Gorgen, that unfortunately, even after the ratification of the Convention Against Genocide in 1948, there was at least a decision from the international community to prevent and prohibit a genocide, they couldn't. Unfortunately, the international community was failed to prohibit, to prevent genocide. But one more point that unfortunately the international community also was failed to heal the injuries after the genocide. And we have different examples, the Yazidis in Iraq, but also the issue in Nagorno-Karabakh is also an excellent example how international community was not successful to not only to stop genocide, but also to stop the consequences. And to be honest, the consequences of the genocide are somehow more horrific than the genocide itself. By the situation of the Yazidis in Iraq, for example, 10 years ago, ISIS committed crimes against humanity, crimes of genocide against the Yazidis. 500,000 people were displaced. More than 10,000 were killed, 6,500 women and children were enslaved, sexually abused. Today, after 10 years, still 65% of those people are displaced, living in tents. You can imagine that children in the age of 6 years at that time, now they are 16, they never found a house in the past 10 years. This is the point. And also regarding the sexual slavery, we have still more than 2,600 women and children in the hand of ISIS, although ISIS officially defeated. A point that I would like to return back to the scope of your panel, the actors, and I would say we have two kind of actors in affecting the genocide and consequences of genocide. One of them is negatively the geopolitics, and the example of the Yazidis, how they are suffering since 10 years, and the problem are not solved because we have geopolitical problems in the region of Sinjar and generally in Iraq, and the political actors, political power in Iraq still was not successful in implementing justice, in implementing accountability, and also to establishing a national agenda for transitional justice. And the example of Nagorno-Karabakh, the geopolitical situation of the people affected the whole world to hear the suffering of the Armenian people who are displaced. Nobody speak about 120,000 people who have no home more. So this is the negative power of the actor of regarding genocide, but we have at the same time, and I heard, unfortunately, with the bad internet, some sentence from the panelists regarding the effectiveness of the civil society in regarding rising voice of the victims, also rising rights of the victims. And I think it is an excellent issue that activism, civil society, human rights activism is playing a crucial role. What is missing, the other wing, how we, when we bring the voice to the people, how the power or the policymaker are able to react with that. And this is, there is a huge need for changing and to empower at least the role and the lobbying of civil society regarding prevention and regarding also defending human rights. In the case of the crimes and also before crimes happen. Unfortunately, until now, we see that everybody is watching. We see, for example, development and there are really some concerning signs. The hate speech, also the background of those militias who are occupying now New Syria. And we don't know, we know that the many states were collaborating in order to defeat the Bashar regime, which was really a criminal regime that had supposed to be defeated in past 14 years. But after 8 million of Syrian refugees lost their houses, a group of militia that we don't know what they are going to do with the Syrian people, with support of some states, now are on the power in Syria. So these are the examples that we, unfortunately, in such important meeting like the global forum, and experts and rapporteurs and people who are engaged in this human rights field, they are warning from the whole day before such thing happened, but unfortunately the things are going and nobody stop it. I think this is a question how we should reform the mechanisms on the international level, how we find. I think there are many points on the UN level should be reformed in order to avoid any other new crisis and these horrific crimes against humanity. I will stop in that point, not that my internet will corrupt, but I am on my way to Yerevan, and I promise to at least to join you at the evening if anybody have a special question regarding the situation or regarding the situation in Iraq or minority affairs in my country. Thank you very much, Gorgen.
Thank you very much, Mirzai. We hope you will have safe travel to Armenia. So now we have another 10 minutes. As soon as we started 10 minutes later, we have 10 minutes for our Q&A, and I will kindly ask our panelists to answer very shortly and so we can collect as much questions as possible. And as soon as I have a privilege of the moderator, I will ask the first questions to the panelists. And of course, summarizing the whole panel, what we have discussed, we have international organizations documenting international crimes. Then we have a Council of Europe. It's a legal framework where we can use, for example, the evidence in different matters. And then we have the civil society mentioned by our three panelists. And then the question arises, and Mirza Dinay, I hope you are also already in the Zoom call, and I would be also very much interested in your opinion, because as Ms. Bomberger mentioned, the Syrian case, the Myanmar case, the collection of evidence, there is also another institution called UNITAD, which was also involved in documenting the evidence in Iraq and Sinjar cases, and now it is closed. And we don't know what is going to be done with the evidence. And I think Mr. Dinay and Ms. Bomberger, I would be very interested in your thoughts how to make this kind of cooperation between the international organization and civil society in bringing this evidence. And I would be also very interested in your opinion, how this kind of evidence can be brought also to the politicians, to the other organizations in order to achieve something, because the documentation also finding is already a step. So maybe we'll start, Ms. Bomber.
Okay, very quickly. So UNITAD is gone. However, evidence continues to be collected by the Iraqi government. So that's very important. But where will that evidence go is your question. So I think here we see the international community really in decline. There is no international criminal tribunal for the former Yugoslavia as that existed. There is no comparable one for Iraq. There is no comparable institution for Syria. There is a IIIM, but that's a mechanism. It's collecting evidence. So what we are trying to do as an ICMP in these cases is to make sure that evidence is collected to a standard whereby that evidence can be provided to an international court. So that's number one. Will there be a court? That remains to be seen.
But there are also national courts that may be used.
Well, yeah, to a certain extent in Iraq, to the extent that they do exist, and we'll see what happens in Syria, though. But also there's the issue of the death penalty, which was the big issue with UNITAD. Where will that evidence go and how will it be used? But I think as a standard of evidence, that's a standard that should be used, and that was a standard, for example, that we're trying to use in many other places. But the question becomes now with the system of courts, where will it go?
Fantastic. Mr. Dinay, are you still in our Zoom call?
Yes, Gorgen, I would like to answer this question regarding UNITAD. First of all, so I am not a good fan of UN agencies generally, and UNITAD did a lot of mistakes, but still was the best example of collecting evidence. The problem was with the UN resolution that established UNITAD, there was not an exit strategy for the work of UNITAD. When the evidence are collecting, is the international committee intended to establish a hybrid court, or an international court, or a national court? Therefore, all evidences that have been collected by UNITAD has been somehow partially handed over to the Iraqi government or the KRG. But the Iraqi government, as you know, in Iraq, we have to, we deal with the crimes of international crimes, unfortunately, just according to the Iraqi penal law. Iraqi penal law has no any sentence about the international crime, genocide, or crime against humanity. This is the first point. The second point, that in Iraq, the terrorists will be just punished according to the anti-terror law, which is a kind a controversial law that the whole UN agencies and human rights the mechanisms are against. Therefore, UNITAD was not successful to communicate with the Iraqi government, and now we're stuck here. So there is no new court in Iraq. Most of
Thank you very much. I'm sorry to stop you. Yes, I'm sorry to stop you, so we can have more answers and questions. If you want to give a remark on that, or a short remark, very quickly.
I didn't really understand the question. You're asking how civil society can use that evidence?
Yes, the evidence, yeah.
Collected by UNITAD?
By every international organization, or by any, even by themselves.
Well, first you need to have access to it. I'm not sure UNITAD's evidence is accessible to civil society without special requests. So, I mean, it depends. It's a very big question. I would say it's important to have coalitions of NGOs produce reports where they're lacking and give their legal analyses. So, so long as they have access to that evidence, they can create these reports that then become advocacy tools to advance further accountability.
Also to reach the politicians, right?
Yeah, exactly. Yeah.
But what happens when civil society is completely marginalized, as it is in Iraq?
So we have a question. Here, I would kindly ask our assistants to bring a microphone over here, and then there and there. Quick questions, please. Summarize it if possible.
Actually, it's a summarizing comment. I would like to thank all the panelists, and I sense that there's many courageous people in this room that are active in all the processes against mass atrocity crimes, including genocide. And I would like to especially thank Mrs. Bomberger, because your work means that also incredible support is given to families who are not left alone in this process of searching for missing persons, and also giving a strong message to perpetrators or future perpetrators that they will not get away with it. So this is really, really important in the Balkans, and I think you just have to continue in all other places as well. Thank you.
Over there? There? Third row?
Thank you so much for the presentation. So just a quick note, it would have been nice to have some human rights advocates from Nagorno-Karabakh in this room to listen to the conversation. I think they could have learned a lot from this. What do you think that we can learn from the Nagorno-Karabakh case in genocide prevention in the future?
Can you pass the mic back?
Thank you very much to all the expert panelists for these prismatic perspectives on the array of actors that needs to be involved in this project. One constituency that we didn't hear about is there a role for the private sector in the investigation, prosecution, and ultimately, hopefully, restorative justice in atrocity space? And just to get us thinking, I'll throw one idea out there that has recently been proposed by my mentor and friend, Ambassador David Sheffer, which is the use of social bonds to address victims, the needs of victims of mass atrocities when we know resources are so constrained. And in a recent report with the U.S. Holocaust Memorial Museum, he applies this model to the ICC as well as the Trust Fund for Victims, as well as the Commission for the International Justice and Accountability, and others. So thank you.
Thank you very much. And then to Mr. Ocampo and Professor from, yeah. Here and there. And then we go quickly answering all questions and then finalize.
Yeah, my question is to Lord McInnes. How can we help the UK government to be on the right side in Nagorno-Karabakh?
And there, the mic. Mr. Ocampo, can you pass the mic?
Thank you. My question is for the whole panel, and it results about your mention about the courage of people, and how it's possible to ensure to make stronger the courage of people, of individuals who are involved in our fields.
We can start answering, please.
Shall I answer on Nagorno-Karabakh, the two questions? I mean, I think fundamentally, and it goes to the point that Sheila was making, if you look at France, you can see where a popular will and an emotional attachment to Armenia and Armenians beyond the diaspora was very effective in shaping President Macron's view. You know, he is not the most popular person in the world or in France at the moment, but I think he showed real bravery in standing up around Nagorno-Karabakh in a way that the UK didn't. Now, there are obviously, both countries have significant geopolitical interests and connections with Azerbaijan as well. But I think it's a really good example of where, if there can be that popular will and activism, it can actually work. And that, unfortunately, was lacking in the UK beyond the diaspora and advocates of the diaspora in Parliament. And I think, just very quickly on Sheila's point, it demonstrates it's important to go outside NGOs as well and go to individuals, because there is a constant echo chamber of the same people in every state speaking to one another that doesn't reach the populace who actually affect the public will that then affects the politicians.
I want to quickly try to answer Rasmus's question. What can we learn from the Nagorno-Karabakh situation on genocide prevention in the future, right? Just, I mean, I kind of wrote my talk around it in that apathy and desensitization is real. So we watched this happen with a lot of statements of support being made, but no action being taken. Conflict fatigue was one of the real problems. It was a long-standing, protracted conflict. The normalization of violence, you know, if it didn't reach this huge threshold with big numbers, it's not important. And you know, it's not a strategically, Armenia's not, and Nagorno-Karabakh are not strategically that important. So it's like, if you want to be taken seriously as an actor who advocates for the prevention of genocide and atrocity crimes, I really think that these two factors need to start becoming more and more prevalent, because then you have a situation, you have this small but very powerful example of it completely failing, the system completely failed. And if we allow the situation to remain this way, it completely legitimizes the ethnic cleansing that happened. It's only going to be a recipe for worse. I mean, I don't want to say impunity leads to emboldening perpetrators. We know that, that's obvious. But this will actually solidify, crystallize a crime into having been kind of okay. Like, it's okay for, if these things happen, this is okay, as long as it's not too big and too bad. And that is going to lead to more genocide and atrocity crimes. So that's my answer.
Please.
Just two very short points. Rasmus, also on your question, I think the first point that I would say is the the Nagorno-Karabakh, to me, showed the absolutely critical importance of civil society voices, journalists in particular, in terms of actually communicating what's happening in real time, because this was crucial when there was no access being given to any mandated international human rights organization. That's the first point. I think that's critically important. The second point is more of an internal workings reflection I would have. Both Armenia and Azerbaijan joined the Council of Europe at the same time, with the same commitment to ensure that the conflict would be resolved peacefully, more than 23 years ago. And that obviously failed. That wasn't followed up effectively by the Council of Europe, and there has been no apparent consequences now for the egregious breach of that agreement by Azerbaijan to not solve the conflict peacefully, but to do it by force. So I think there's a really important lesson there about what do membership obligations actually amount to, and what do we want to do in terms of following them up.
I want to address the issue of, I think you said courage, right? Yeah. I think one thing that's extremely interesting that's happened over the last several decades when it comes to atrocity crimes, and especially when they're related to missing persons cases, the majority of those missing are men. That happens whether it's conflict, human rights abuses, migration. And what's happened over the last 30 years is the courage of female survivors, of women survivors, for once and for all, to raise their voices. And I think this has had a profound impact. They've been extremely courageous in coming forward, talking about sexual violence, gender-based crimes, but also missing persons cases where they have been silent and marginalized. I mean, I would say even in the case of Armenia, I mean, women, they're mainly women survivors. I met with them yesterday. They are now raising their voices, and this has had a profound impact on ensuring that governments are held to account, that states provide this evidence. So really, that courage has come forward, whether it's the women of Srebrenica, whether it's the women in Ukraine, or the women in Syria, who have taken their case all the way to the Security Council and created a mechanism to deal with missing persons cases. So that has really changed the way we look at atrocity crimes, because they felt marginalized and stigmatized. They felt afraid to come forward. We haven't talked about any of this in this conference, but that has been a very profound and important point.
Thank you very much. I think this concludes our session, our panel today on this topic. I thank to all panelists. I think it was very interesting, and also I enjoyed very much the discussions that we had, your statements, and I wish everyone very good, not lunch, no, we have a coffee break. So I'm already hungry.
Good afternoon. We're waiting for the afternoon to come to start our panel, for it will be some minutes after 12. So good afternoon to everybody. It's a great honor to start run and moderate concluding panel of the conference, of this very, very rich conference with exceptional panelists and speakers. Today we were speaking about heroes, and I was looking at the whole. Everyone in his profession is hero, women and men. Here this fall, it is very exciting to see this, and I'm very excited that my country, irrespective of these difficulties it passed, and I have to say that since Declaration of Independence about 30 years ago, we have seen 3 wars and sieges and different problems, but we didn't go back from our way to democracy. We didn't go back from the way that we think about humanity, that humanity should live in a peace and protection. And this conference, already 5th year, Armenian runs in a very difficult situation when the conflicts have happened in Nagorno-Karabakh and situation is completely changed. We still speak about importance of addressing issues of prevention of genocide and peace. So with this, I want to bring thank you to my country. And the second thing I would like to say, I'm very happy that today we have government officials, but we also have youth who will continue this route, taking these discussions, these messages to their communities, to the institutions, and in future we will have a new generation of experts supporting us. This is a very difficult route, but together we will pass this. And I think this platform is critically important a critically important voice to stand against those other voices that are militarism, militarization, authoritarianism, and we were all mentioning that in a very difficult time. So our concluding panel has a lot to say. We have 3 main tasks to discuss today, and also we have to come with concluding remarks. So first is about international law. We have to analyze flows and gaps in international legal and policy framework and see emerging challenges. And we'll speak about, codification, in necessity of codification of new, so to say, emerging things like hate speech, SAGE. And I would like to add that recently in resolution 2024, a Security Council has addressed already hate speech in his resolution at the threat towards humanity. Second area that we are going to speak about, necessity of systemic study of the evolution and practice of mass atrocity and the early warning mechanism. Again, this was discussed during our panels, but I think we are going to discuss it again in a very details. And the other issue is, our session will focus on warning signs and common risks factors for genocide and other atrocities of the world. And also, the session would highlight the contribution of small states in shaping agenda for prevention of genocide. This is a very important discussion, and I think, many of issues have been already spoken in this audience, like, investment of small states into the prevention of genocide, so eloquently presented by our former Minister of Foreign Affairs, Zohrab Natsakanyan. But Armenia continues its way, and I think we will be speaking on that again. I didn't introduce myself. I'm Gulnara Shahinyan, former UN Special Rapporteur on Slavery. And while everybody was speaking today, my mandate, I started the mandate when it was established, which means that you have to learn from entire structure of UN, how it functions, how it works, and what gaps and problems are there. And it was very interesting to see that when I took the mandate, almost all there have been 2 mandates in UN at that time, mandate on trafficking and then established mandate on slavery, which meant that UN recognizes existence of slavery. But at the same time, many countries have adopted Convention 1926 on slavery, but nothing has been done. So it echoes to the enforcing mechanism of conventions that, you know, we were talking in these days. So when you were traveling to the communities, in communities, you were finding out situations that people were living still as thinking that they have to work for these owners for all their life in order to pay the debt. And issue of, you know, ownership was still in these countries, in many countries. So while we're turning to introducing a new concept, we have to try to finish with the one to understand how the system works. And here again, we were talking today about many important things that, you know, many UN agencies are working in above, making policy without considering situation in the field. And many, not only UN agencies, but also many international agencies in the countries where they are situated, country teams, they travel very hardly to the communities. And that's why sometimes recommendations and documents are not addressing the real needs of the countries. So I would not extend my, you know, speech on situation in with a slavery mandate on the situation, but I would like to give the floor to the first, you know, expert. It is really for me a huge honor today to run this panel because these are experts of high class, and I was very humbled when I read the names and bios. So first my speaker was Matthias Hellmann. He's the head of outreach unit at the Registry of International Criminal Court. And he previously served from July 2010 as external relations advisor, the ICC presidencies prior to joining ICC. Mr. Hellmann served 10 years in the United Nations International Criminal Tribunal for former Yugoslavia, and mostly in field offices, Croatia, Serbia, and Bosnia-Herzegovina. The floor is yours, Mr. Hellmann. Thank you.
Thank you so much, Madam Chair. Dear co-panelists, ladies and gentlemen, first of all, I would like to thank the organizers for the invitation for me to address this forum. It's really an honor for me to do so as a representative of the International Criminal Court. And I would like to also here at the outset give praise to Republic of Armenia's decision to join the Rome Statute of the ICC in November last year. It is a historic decision of enormous significance. We at the court welcomed Armenia to the ICC family with open arms. And now the ICC is Armenia's court just as much as it is the court of the other 123 states parties. And Armenia is now a full-fledged member of the Assembly of States Parties to the Rome Statute, which is the intergovernmental body that is the ICC's legislative and oversight arm. And in fact, the Assembly of States Parties met just last week in The Hague, Netherlands, where the ICC is based. And in his remarks to the Assembly of State Parties, the Minister of Foreign Affairs of Armenia said, and I quote, "Strengthening the prevention mechanisms, such as early warning capabilities, along with the deterrent potential of international courts, in particular International Criminal Court, can lead us to a safer world." End of quote. I could not agree more. I have always found prevention to be the ultimate goal we should aspire to. Of course, where crimes have been committed, we need retribution as well as restorative justice, but surely prevention should be our first priority. The human toll of wars and atrocities is simply so vast that humankind should do absolutely everything to try to prevent them. I personally spent many years doing victim community outreach in the countries of the former Yugoslavia, including Bosnia and Herzegovina. And during that time, I became very close with many survivors of the Srebrenica genocide. And I witnessed, and to some extent I felt, the immense pain inflicted on them by virtue of their sons, husbands, brothers, and other family members being killed in cold blood. And in many cases, the pain of these women, particularly women usually, was further exacerbated by the fact that the remains of the victims were not found, denying the surviving family members closure and the opportunity to mourn the loss with dignified remembrance. And the ICMP, from which we had the representative in the last panel, did a huge job in mitigating that pain by helping to find and identify the remains. So the mothers of Srebrenica yearned for justice, and the ICTY, the Yugoslavia Tribunal, did do a historic job in holding many key architects of the Srebrenica genocide accountable. Yet I remember one of the women saying to me after one of the convictions by the ICTY, something to the effect that, so he's now convicted, so he will go to jail, but does that change my life? I'm still here. My sons, my husband are still dead. So where does that leave me? And, well, in this sense, in this respect, the ICC is a step forward from the Yugoslavian Rwanda tribunals in that the ICC contains a very ambitious and complex system of victim participation and reparation with the precise goal of trying to change somehow the lives of the survivors and the victims by addressing the harm that they have suffered as a consequence of the crimes. And the ICC and its Trust Fund for Victims have already implemented groundbreaking victim reparations in the Democratic Republic of the Congo and in Mali, and are beginning to do so in Uganda. But we all know that complete restoration is impossible in 99% of international core crimes. You cannot bring back the dead, you cannot undo torture and rape, you can do a lot to heal trauma and injuries, but the scars still remain. Thus, again, prevention, prevention, prevention. This is also why I'm so keen on the ICC's deterrent potential, and why it's a huge source of motivation for me to work in a court that is, in a way, a pre-existing court. It's not something that you're going to create ex post facto. This is why the ICC does hold this deterrent potential, because it's already there. Well, where it has jurisdiction, and we'll come back to that. And so I'm convinced that the ICC does hold deterrent potential. And actually, this is not a matter of faith alone. There are many empirical studies which indicate that over time, on average, membership in the ICC system does reduce the likelihood of conflicts and atrocities. While these academic studies are far from uniform in their conclusions, they all support the contention that the ICC can deter. There are two main types of factors here. One is joining the ICC system, ratification of the Rome Statute, and on a related point, domestication of the Rome Statute by including crimes, international criminal law, cooperation provisions, and so forth. And then the other major factor is ICC action in the form of preliminary examinations, investigations, trials, convictions, possibly also acquittals. I would insist that acquittals are also a form of accountability. Of course, there may be dissatisfaction, disappointment by victims sometimes if at the end of the trial, the accused person is not actually found to be the responsible one, but it still means that someone was held to account, and there is a basically, even that can deter the prospect of being put on trial, regardless of the outcome. Rome Statute ratification and domestication has been found to be significant, particularly in deterring crimes by government forces. Where it comes to rebels, on the other hand, ICC action, such as concrete investigations and prosecutions, has been found to be very significant. So there are different factors at play, and the research is still evolving, so, and also because the ICC's work is still evolving, so I'm sure that a lot more empirical research should be done. But there is a big body of scholarly studies out there already, and I'd be happy to give a reference to anyone who is interested. A factor that comes up repeatedly is the likelihood of action by the ICC. So there's going to be a greater likelihood of deterrence if there's a real threat of prosecution, if it's seen as a real possibility. Now, and also, I would add that the research tends to show that ICC membership and ICC action do not lead to an increase in violence, which has sometimes been feared by some. So, in other words, academic studies lend credence to the contention that the so-called peace versus justice debate is a false dichotomy. So justice does not undermine peace, and it does not risk increasing violence. Also, justice supports sustainable development. Look at Sustainable Development Goal 16, or look at, for instance, World Bank's 2011 World Development Report, which highlighted that investment in justice is essential to reducing violence. The ICC's deterrent effect, of course, depends on the court's legitimacy and effectiveness. And that, in turn, depends on several factors. And I want to discuss two of them, which are commitment of states, and coverage of the ICC. This is also where we come to the gaps, as per the topic of this session, and how we can address some of the challenges and what the challenges are. So first, commitment of states in particular. We need all the states parties to the Rome Statute to support the ICC fully and cooperate fully with the ICC in line with the Rome Statute. I mean, the truth is that today support for the ICC is neither global nor unconditional. And to achieve that, we need relentless, forceful advocacy from states, as well as from international and national civil society and various professional organizations and other organizations. We need ICC states parties not only to fully support the court, we also need them to oppose the attacks and threats against the ICC, a phenomenon that is unfortunately very part of reality today. Now, when it comes to, so that is about the commitment of states, and it really needs to be firm, and the commitment should be there even when the ICC sometimes takes action that may not be fully in line, or at least perceived to be in line with national interest of a state. I mean, I hope that the ICC becomes really accepted in the same way as courts are accepted in the national system. It's something that needs to be there. It's part of the rule of law. Even if you sometimes don't like a ruling by a court, you will respect it, because you know that if you don't respect the courts, chaos will ensue. You need the rule of law. Okay, then I come to coverage, and this is the last part of my talk. So commitment is one of the challenges where we are not quite there where we should be. We need stronger and more consistent commitment. We also need more coverage for the ICC, because of course the ICC cannot deter crimes where it does not have jurisdiction and where it cannot act, because the ICC does not have universal jurisdiction. Basically, the ICC's competence is limited to the territory of the states parties and crimes committed by the nationals of the states parties. But where crimes occur in a country that is not part of the ICC system, committed by people who are not nationals of ICC state parties, the ICC has no legal powers to act. So we have currently 124 states parties, soon 125, because Ukraine has recently ratified the Rome Statute and is becoming a state party on the 1st of January. But unfortunately, still the majority of the world's population actually falls outside the reach of the ICC's jurisdiction. But I remain optimistic that slowly but surely the number of state parties will continue to grow, and Armenia's and Ukraine's recent actions give us hope that that is indeed so. Now, people often ask, why should states join the Rome Statute? What's in it for them? Well, there are several reasons. First of all, it's a powerful foreign policy statement. You are showing that, okay, our country is committed to international law, peace, security, human rights, rule of law, etc. It's also, one other reason is that you will become part of the system. You can participate in shaping the evolution of the ICC, which is a major pillar of the international legal system. So you'll be on the inside and not just looking from the outside what's going to happen. And finally, deterrence, legal protection. Not just deterrence at home for your country and your people, but elsewhere too, because by joining the Rome Statute, you strengthen the ICC's ability to act and to deter everywhere. You strengthen the system. So it's not only about your narrow national interest. It's also about solidarity with victims and basically people everywhere on earth. It's about commitment to building together a system of the rule of law at the international level for the sake of a safer and more just future for humankind. It is a long-term project, and I'm grateful that we can now count on Armenia's commitment to it. Thank you.
Thank you very much, Mr. Horde. And you raised a very important issue about prevention, importance of prevention, and importance also of peace and justice. If the countries are joining ICC, it doesn't mean that the violence would extend. So it means that there will be peace and justice. So these are extremely important. And you answered all the questions that were in our society, raising when Armenia joined ICC. There were numerous questions. What does it give? What will Armenia would gain from it? These were all the answers given. And thank you very much. My speaker on the list is Peter Prove, Director of International Affairs, World Council of Churches. Since 2014, Peter has been Director of Commission of Churches on International Affairs of the World Council of Churches, responsible for WCC's activities in the fields of peace building, disarmament, human rights, and for WCC's relations with the UN system. He also a lawyer, and he had extremely big experience representing faith-based organizations in the international arena. Before joining WCC, he was more than 12 years Assistant to Secretary General for International Affairs and Human Rights at the Lutheran World Federation, and the 4 years Executive Director of the Ecumenical Advocacy Alliance. The floor is yours, Mr. Thank you.
Thank you very much, Madam Moderator. I have to say it's a great honor to be participating in this very important gathering, this 5th Global Forum, and especially to be joining a panel such as this with such eminent experts and speakers. So I represent the World Council of Churches, and for those of you who may not be very familiar with us, we have 352 member churches in about 140 countries now, I think, representing a total constituency of about 580 million people. I believe that my first visit to Armenia was when I took part in a meeting of the WCC Executive Committee hosted by the Mother See of Holy Echmiadzin in June 2015, during the centenary year of the Armenian Genocide. Last year, on the 19th of September 2023, I was at the entrance to the Lachin corridor as the final attack on Artsakh, Nagorno-Karabakh, began. I could hear the thud of the artillery shells just across the mountain. But I'm very honored to be back here participating now in this 5th Global Forum against the crime of genocide, and I thank the government of the Republic of Armenia and all the participants for this very important conversation. There have been many occasions over the years on which the WCC has called for recognition of the Armenian genocide by the United Nations and by UN member states, dating back at least, I think, until 1979. We believe that there is a duty on the international community to acknowledge and remember the victims of genocide in order to heal historic wounds and to guard, most importantly, to guard against similar atrocities in the future. Denial, impunity, and the failure to remember such events encourage their repetition. But here we are, in December 2024, in the midst of proliferating conflicts, record levels of hate speech and incitement to violence, declining respect for the principles of international humanitarian and human rights law, and evidently increasing incidents of serious international crimes, and with genocide back on the news of the day. But while political will to prevent such crimes seems to be failing, the international legal tribunals of adjudication of such crimes, in particular the International Court of Justice and the International Criminal Court, seem to be taking on greater salience, stepping into the political vacuum and staging a kind of stately judicial fight back. And I, as a lawyer, really celebrate the importance of these instruments stepping into this space and taking this role. This panel is supposed to focus on gaps in the international legal and policy framework and challenges for the prevention of the most serious international crimes. So let me speak to that. First, I have to highlight the limitations inherent in the framing of the Genocide Convention. As we know, the process of establishing the 1948 Convention required significant compromises from UN member states to be realized. Such compromises included limiting the protected groups and leaving out acts of cultural genocide or the destruction of sacred places such as houses of worship, grave sites, and heritage sites as a means of destroying a group. Second, in many cases of violent conflict, it is, we've repeatedly acknowledged this, nearly impossible to prove dolus specialis, or specific intent to destroy. Although I'm sharing a panel here with somebody who did just that, but it is very difficult. And it is required for an act of violence to be considered as an act of genocide as defined by international law, both under the Genocide Convention and the Rome Statute. Indeed, for 50 years following the 1948 Convention, there was literally no practice at all in relation to the crime of genocide before national or international courts. However, that changed in the 1990s with the collapse of the former Yugoslavia and the crimes perpetrated in Rwanda. In the absence of documents or other direct evidence of such specific intent to destroy a group, courts have been left to infer intent from a pattern of behavior. The International Court of Justice, in a judgment of 2015, described the way in which you infer intent as follows. In order to infer the existence of the dolus specialis from a pattern of conduct, it is necessary and sufficient that this is the only inference that could reasonably be drawn from the acts in question. The only inference. That is a very high threshold. It means that if someone has a double intent to defend themselves and to destroy a group, it could be said that the necessary inference could not be drawn. Victims of atrocity crimes often feel the need to compare their experiences to legally established genocides, such as the Holocaust, the 1994 genocide in Rwanda, and the 1995 genocide in Srebrenica, to establish legitimacy and to seek an adequate response. We've spoken here of genocide as the crime of crimes. But from a legal point of view, there is in fact no hierarchy between war crimes, crimes against humanity, and genocide. There is therefore an argument for shifting the narrative from genocide being considered as worse than other crimes to considering these crime categories as different, yet of equal importance and impact to victims and survivors and to the broader international community. On the other hand, the Genocide Convention provides access to the International Court of Justice to address allegations of genocide, while there's no equivalent route to the ICJ for crimes against humanity and war crimes. And it's obvious that in political and general public discourse and in the media, the term genocide carries great weight and impact. Still, as Samantha Lakin has proposed, an important and less regarded way of using these legal definitions and crime categories is as a type of diagnostic tool. The categories of war crimes, crimes against humanity, and genocide can help us understand the patterns of violence and the political, economic, and social factors that lead to such crimes, and to contextualize and understand risk factors in order to strengthen prevention strategies. Another challenge, and I have to say a very provocative perspective, was highlighted in a recent article by Philippe Sands, and that is that the concept of genocide has reinforced matters of group identity, which did not exist in international law in the same way prior to the invention of the term. According to Professor Sands, the requirement of proving intent to destroy a group in whole or in part has, and I quote, "In my experience doing cases over the last 25 years in the field of genocide and crimes against humanity, reinforced intergroup hatreds." The invention of the concept of genocide, no doubt very well intentioned, may have given rise to the very thing it was intended to prevent. The invention of the concept of genocide could actually give rise to more genocides. Unquote. A very provocative perspective. In any event, it is clear that consistent and non-discriminatory accountability for the most egregious crimes is an absolute necessity for the prevention of future such crimes. This brings me to the challenge of enforcement, a general challenge in the field of international law. A couple of months ago, Professor Hilary Charlesworth, a member of the ICJ bench, spoke at the Geneva Graduate Institute on the topic Hopes and Fears for International Law. She gave, in my view, a very wise as well as elegant response to a question about the utility of international law, and specifically of ICJ rulings, in a context in which most such judgments are, frankly, ignored and unenforced. She acknowledged the challenge of enforcement, but described the role of the ICJ as providing a legal thread, itself thin and weak, that can be woven together with other threads, political, social, cultural, and even religious and spiritual threads, into a web of effective enforcement. I loved her for that observation. But she thereby presents a challenge to all of us, not to throw up our hands in despair at the weakness of international law, but to take that thread and weave it together with other threads that we may have in our hands to create that web of effective enforcement. Now, that's my mic drop moment. I should really just stop right there, shouldn't I? But I'm going to mess it up, because I have to also present one of those religious threads for your consideration. And that is the plan of action for religious leaders and actors to prevent incitement to violence that could lead to atrocity crimes. Okay, it's the longest title ever created for such a plan of action. But it's something that we worked on together with the Office for the Prevention of Genocide and Responsibility to Protect, together with many other partners, interreligious partners, to develop that plan of action. And we consider it to be very important. Likewise, the subsequent guidelines on addressing hate speech and the cooperation that Mario referred to yesterday, the cooperation between the Office and religious leaders and actors in implementing those guidelines. I see this really as a key contribution by our sector, the religious sector, in helping to fill the gaps and addressing the particular challenge of hate speech, which lacks international legal codification, but which is a growing threat in very concrete ways. And I think in particular of Ethiopia as a situation of high concern for us in this regard right now, but sadly also in many other places. So I commend this, I offer this thread to you for your work in weaving a web of effective enforcement. Thank you.
Thank you very much, and thank you for being with people of Artsakh at this very difficult times when they needed real support. And thank you for speaking about cultural destruction, because again, as for many people in the world, for the gaps in the law, for any people in the world, cultural destruction is equal to human destruction. Specifically, also when people of Artsakh were mentioning the destruction of their cultural monument, it was like loss of close friend, close relative. They were so much taken with it, and this is very important to really address this gap. And the last message which you meant about, you know, not look for the gaps, but look for the changes. Be more proactive. I think this is critically important. Thank you very much. My third speaker is Yerevan. a person is well known in Armenia and outside. Yerishe Kirakosyan serves as representative of the Republic of Armenia on international legal matters. In this capacity, he represents Armenia in proceedings before the International Court of Justice, the European Court of Human Rights, investment in commercial arbitral tribunals, foreign courts and media fora. Since 2008, Kirakosyan has held various governmental key issues. And also he has in addition to his extensive public service, Kirakosyan has been engaged in academia, teaching at various universities in Armenia. As I said, when Kirakosyan is the most popular person, when he is presenting case at the court, entire Armenia looks to television and they're watching what will be said and what reaction would be. Thank you for your service, Mr. Kirakosyan.
Thank you. Thank you for the kind words. It's obliging for me, and it's an honor to speak among the distinguished experts of panel of experts, and thank you. It's an honor to speak in the framework of the Forum Against Crime of Genocide. I will be speaking mostly based on experience that Armenia had in the past years attempting to enforce and apply international law and applying it to different international courts. Before going to that, just a rhetorical question that maybe I start my presentation. What is international law and how we perceive international law as it is? In the previous panel, I think one of the panelists mentioned that the international community consists of the states, and we are the international community. And international law is also a legal system that is based on national legal systems. And it's enforced through national legal systems. Why am I emphasizing this? I'm emphasizing this because the effectiveness and efficiency of enforcement of international law largely depends on the principle of rule of law inside the country, mostly. And that phenomenon has been studied extensively, and it's being, numerous articles are being written about the topic. And today we face this reality of divergence and challenges of international that faces today. And my understanding and my observation also as an academic, also as professional, is that in the past decades or so, the system that has been built after the end of the Second World War has been experiencing a lot of tectonic changes. One of the reasons I would describe is the depart of many societies, many countries from the proclaimed values. The gap that starts to emerge between the proclaimed values and the rules that are being adopted between the countries and the reality on the ground. Why it happens? I think one of the reasons, one of the challenges that makes it happen, I think, is the difference, of course, the countries that I have, and of course the difference of the political system of the countries that I have, and of course the political changes that are happening after the geopolitical changes, like in the early 90s. And also the technological advancement that created the possibility for the rapid travel of the information and data, which also allowed many countries, specifically those countries which are not that much governed by rule of law, more autocratic countries, to start abusing the system a little bit, and start abusing and creating this fog of the different concepts and narratives, aggressive narrative building, which is specifically evidenced in conflicting situations. I think this is one of the reasons why this gap has been created between the reality and the proclaimed values, which I think, to my understanding, also is somewhat due to the shortcomings of the challenges, the shortcomings of the human rights system or human rights mechanism that we have globally and regionally, including also the treaty mechanisms, for example. But in any case, today, disregarding the fact that the international law faces unprecedented challenges and the enforcement of international law is doubted by everyone, and I think most of the people, I'm sure that most of the people present in the room will be very much skeptical about the courts, about international law in general. But at the same time, there's an interesting phenomenon that happens in the past 10 years or so. There is a very huge wave of countries directed towards international courts. Mostly small countries, like in the past years. If you look at the docket of the ICJ, you would notice that the caseload increased rapidly in the past 10 years or so. What does it mean? Why is it happening? I think the answer to the question is very clear. Countries need a rule-based system. Countries need a predictable rule-based system. They don't want chaos. And mostly, I think the countries that are the smaller countries, not the large countries with lesser political weight than the bigger players, they are the ones who are attempting at enforcing international legal order eagerly. And I think that's one of the reasons also, this also creates this kind of dichotomy, because from one end we have these malfunctioning institutions with huge problems, but from the other hand we have this drive by the countries to enforce the existing institutions, because we do not have other institutions to deal with. So we have the ones to deal with, and that's I think the only way to go through is to go through the enforcement and understanding of the challenges and trying to resolve them. From our perspective, I think I would say that because of these few institutions that the international law does have, I think most of the institutions has been put in a spot that they're not being created for that purpose, for example. And I wouldn't be so naive to expect that, for example, in a very complex conflict-related cases, the decisions of the courts or the judgments of the courts would be immediately abided by, including by the ICJ or the European Court of Human Rights, especially. I understand, especially with the cases that we are speaking about, I mean genocide or crimes against humanity or other grave violations of international law. Also, the case that Armenia has at the International Court of Justice based on the Convention on Elimination of all forms of racial discrimination. Why? Because if you have a country that breaches this fundamental provisions of international law, those are the fundamental principles of international law, you cannot expect the country to suddenly, by a miracle, transform into a beautiful, law-abiding country governed by rule of law and the equality of everyone. That won't happen. You cannot demand the international legal system to apply like immediately. It takes time. It really takes time. But it doesn't mean that international legal order doesn't have an impact. Even in cases that international court decisions are not complied by, I truly believe, and we have been experiencing that in our own example, that international court decisions, and even not only decisions, but also proceedings themselves, they do have a very specific and direct impact on state behavior, also including autocratic states. But the problem is that also if you look from the other side, that also, I was speaking about the abuse of international law, about the noise that has been created by mostly autocratic countries to play with the system, to play with the international legal system, is also the other part of the problem. Because most of these countries, autocratic countries, they tend to see international legal institutions as an impediment for relations between countries, not as a tool for resolving differences between the countries. Rather, even some countries would say that it's actually against the peace. So, which is appalling, I would say, because the institutions per se have been primarily created for peaceful resolutions of disputes between states, as a civilized method of peaceful resolution of disputes. I think that's very important. And I think cases that, by the way, we have at the International Court of Justice. For example, one of the cases, a very interesting case about the application of the Genocide Convention, Ukraine versus Russia. Why am I mentioning this case specifically? Because this case exemplifies also what I'm trying to convey. I mean, the problem with the abuse of international law. Because if you are attentive to the case, the philosophy of the case, it's reverse application or attempt of reverse application of the Convention for the Punishment of the Crime of Genocide. That's a unique way of approaching that. And I think that's an indicator that something is happening in the international community, something strange is happening. I think that's one of the challenges that I would underline. And coming to the ICC, since I don't have much time, I just want to make a couple of remarks about the International Criminal Court, marking also Armenia's joining to the court, and Armenia was participating in the ASP last week in The Hague for the first time, and ICC is also highly criticized, and of course in Armenian community we do have this criticism too, that people do not see the immediate justifications why Armenia joined. Because the expectations from joining to the court were really high or heightened. And also the work of the court is very special, and I think it needs to be explained to the public what the court does and actually does. But I truly believe, I'll conclude with this, that even the ICC, I think maybe ICC even more, even compared to the International Court of Justice or even the European Court of Human Rights, has much more, or is potentially having much more impact on a country's behavior. Why? Because as opposed to the International Court of Justice and the European Court of Human Rights, which deal with an abstract notion of state responsibility, International Criminal Court deals with individual criminal responsibility of specific persons, which are the leaders of the country. That's why I think the potential jurisdiction of the ICC can have much more effect on state behavior even than the international courts which deal with interstate disputes. With this, I think the overall structure and the applicability or attempts of enforcing the international courts or enforcing the international law through international courts are a very important component for ensuring security and peace. Because those two, those are the only institutions that we have. I think I'll stop here, I'll conclude, and I'll wait for any questions that may arise. Thank you for your attention.
Thank you so much for this comprehensive explanation. And again, you answered all the questions which were in the society, why we joined, what it gives to us, what is ICC and what is ICJ, interrelation of this. This is critically important for us to understand. Specifically, as I said, they are young people from university. And these questions are always arising in society. What do we need? Why do we need it? So thank you, Yerevan. Our next speaker is Henry Trialon. Yeah? Yeah, Tarlow. He is Associate Provost, Western State University. He has PhD and, in this university, and he works in the United States. And he teaching philosophy in philosophy department from 1998 to 2017. He coordinates a human rights center. He coordinated Human Rights Center. He researches genocide denial, genocide prevention, post-genocide victim perpetrator relations, reparation, and mass violence against women and girls. He is the lead author of Armenian Genocide Reparation Study Group in 2015, Resolution with Justice, and he is also authored with Samuel Totan and co-authored the book with other authors, Aftermath, is also co-editor of Aftermath of Mass Violence. His work has appeared in many languages, also in Armenian. And I would like to thank you for your, attention to Armenian case and your writing about Armenian case. Thank you. The floor is yours, Mr.
Thank you very much, and thanks. You did a great job on Worcester, so that's one of the toughest words to pronounce. So thank you. Our ability to prevent genocide is greatly hampered by certain misunderstandings. Decisive progress against genocide depends on exposing these inaccuracies and facing reality as it really is. In this presentation, I'll discuss 6 debilitating fictions. First, our basic notion of definition commits us to the view that words refer to objects that are unchanging over time. Genocide, however, has been evolving with human social development over our entire history. A definition formulated at any given point is at best a good empirical generalization based on prior cases. If Lemkin had formulated his ultimate concept of genocide in the year 943 instead of 1943, he would have come up with a markedly different definition. While legal and other experts have done their best to stretch the UN definition, this need itself reveals the instability and variability of the concept of genocide. What is more, our flexibility has limits, and cases of mass violence on the margins of the definition are often excluded from the category. The very need for flexibility introduces an element of subjectivity or bias, as well as chance in determining which new cases are and are not genocide. In addition, perpetrators read the same legal codes and texts we do and witness the same court cases. And attentive perpetrators have learned from these how to work around the law against genocide. Perpetrators develop methods and even structures of mass violence that have a family resemblance to the received notion of genocide, but are different in ways that make it difficult to take political action based on received legal approaches to genocide. For example, Serbian architects of genocide seem to have emphasized mass rape as a preferred and compulsory tool of genocide because they calculated correctly that the international community would not see rape as genocide, while they would see mass killing as genocide. One might counter that in the 1990s, rape linked to genocidal intent was recognized as an act of genocide, but this happened only after the events we're talking about. The decision to intervene to stop the Bosnia genocide did not come at any point while tens of thousands of women and girls were being raped hundreds of thousands or even millions of times, but only after more than 7,000 men and boys had been killed. It is only when we approach an emergent case with an expectation that there will be aspects that make it a novel form of genocide that does not fit well into the existing definition, that we will be able to avoid allowing international law to be exploited by clever perpetrators. Second is our belief that advances in human rights rhetoric correspond to real concrete progression in human rights protection. On the contrary, we might notice a rhetorical turn in the 18th century when democratization and a growing commitment to general rights was met with new forms of rhetorical manipulation that tended to preserve the role of power differentials and violence in human affairs, while at the same time reassuring humanity in general that the rhetorical advances were actually meaningful. Only by recognizing that law, politics, and ethics are rhetorical elements, that their relationship to the brute reality of human suffering can be manipulated, and that we are always already working within a compromised space in which nothing is as we want it to seem, can we develop more sophisticated critical thinking tools and methods of education that can address the rhetoric-reality split. Third, much of our long-term prevention work depends on a particular notion of why people commit genocide. There is perhaps no greater article of faith in genocide studies than that dehumanization is essential to perpetration. While dehumanization does occur, that does not mean that it is necessary to genocide, nor that it is a cause rather than an effect of genocide. While this fetishization of dehumanization causes us to de-emphasize or miss perpetrator superhumanization, That is the tendency of perpetrators to see themselves as godlike beings above the human crowd, entitled to instrumentalization of others, as well as to satisfaction of desires to inflict suffering on others. Notice that most execution of genocide involves much more violence, torment, and cruelty than is necessary to destroy a group in whole or in part. Notice as well that the enjoyment of genocidal cruelty actually increases the more the victims are seen to be fully human. And some practices, such as separating families, make sense only when victims are viewed as intellectually and emotionally complex and ethical human beings, not subhuman vermin or diseases. Why does this matter for prevention? First, dehumanization theory supports the view that wrongdoing is based on an intellectual error. This is the old Socratic and even Christian way of approaching ethics. Second, we really want to believe that the innocent mistake account of wrongdoing, because the alternative is that people just like us, willingly, wittingly, and with enjoyment, choose to harm people in the most horrific ways possible. We construct genocide around this model. But if genocide is not based on, or only partly based on, an intellectual mistake, then this approach is not an effective prevention strategy. Recognition of the importance of education to prevention requires us to do a better job of creating the content based on an analysis of all the forces driving genocide, not just the ones we are comfortable acknowledging. Fourth, to modify Nietzsche's view a bit, law supports justice only between parties with equal power. I would add that law, in fact, exacerbates the asymmetrical power differential between dominators and the subjugated, birds of prey and lambs in Nietzsche's language. That is not to say that the oppressed have not figured out ways to use law against those who wield it as part of systems of organized violence, abuse, repression, and exploitation. But now we face the repressive reversal of that progressive inversion as a reassertion of the attitude that drove Athens' genocide of the Melians more than 2 millennia ago, the Thrasymachon formulation that justice is the will of the stronger has emerged in recent years with great effect. An eerie echo of the Athenian negotiators' response to the call by Melians for Athenians to adhere to a moral order in which might does not make right, Ilyam Aliyev affirmed the horrible truth that in today's international arena, might unabashedly makes right when he mocked Armenians' appeals to international law against the 2020 invasion of Artsakh, Nagorno-Karabakh, by saying that international law had become irrelevant on the global and domestic stages, and only power mattered. The fifth mistake concerns the notion of cycles of violence, in which former victims become perpetrators, and perpetrators become victims in a new round of violence, and so on, back and forth. Peace is thus viewed to depend on an actually counterproductive relativism based on the assumption that victims are all inherently perpetrators and vice versa. While cycles of violence do occur, they are not the norm, let alone inevitable. Some victim groups do become perpetrators, but even more to the point, that is not really because they are victims, but rather for the same reasons that most perpetrator groups do: ideology, avarice, and so forth. Reperpetration and revictimization, however, are norms. And when perpetrator groups reperpetrate against the same victims in what can be called oscillating genocide, or against new victims in what can be called serial genocide, they do so for the same reasons as the originally committed genocide, augmented by the impunity they typically enjoy for their past violence. Committing genocide reshapes perpetrator societies, and the process of violence and creating and molding mechanisms to carry it out embed genocidality in their state and societal institutions, practices and behaviors, and attitudes. Genocides by Turks and eventually Azeris, sharing an exported anti-Armenianism, against Armenians in 1894-96, 1915 to 1923, and 2020 to the present, you could add a few other years in there, by the way, but we'll leave that alone, are a matter of repetition of mass violence against a specific group. include the Kurds, and we see seriality as well. The 2000s genocide in Darfur has been followed by a 2020s reactivation. The Serbs moved from Bosnians to Kosovo Albanians, while Indonesia moved from so-called communists to East Timor. And cases like this again and again and again are prevalent, probably no more so than the targeting of indigenous peoples in North and South America over a process of centuries involving multiple perpetrators and hundreds of distinct victim groups. Why repetition? There are a number of particular reasons, including increased impunity for perpetrators, increased association of previous victim groups with victimization so that perpetrators and bystanders see violence against victim groups as normal and acceptable, an increased concrete power differential that entails even more capacity for perpetration by the dominators and increased vulnerability for victims, and resurfacing of embedded genocidal attitudes and/or habits in political, military, cultural, religious, and other institutions and practices. Underlying this set of reasons is the non-rehabilitation and/or non-incapacitation of a perpetrator group. Accountability through criminal and reparative justice is essential to preventing repetition and thus a large number of cases in the future by oscillating or serial perpetration. The final problem, and I'm getting to the end, is the global hierarchy created by bystander perceptions of victim groups. While the world focuses great attention on certain cases, many victim groups are attacked and even destroyed with hardly a notice by mainstream media and even many of the organization and governmental entities sworn to protect them. Has the American Friends Service Committee, for example, even mentioned Nagorno-Karabakh in the past year, while sending nearly daily emails to get support for Gazan Palestinians? Don't get me wrong, I applaud their work to stop the violence against Gazan Palestinians, but what about other groups? In any era, the majority of victim groups are what I'll call the damned of history, whose suffering is ignored by policymakers, journalists, and others. Where does all this leave us? Maybe I am whistling in the dark, but I'm going to end with a message of hope introduced by the Steinbeck slogan of a problematic origin that we won't get into, which I will paraphrase as, for every step forward in human progress, there is inevitably a half step back. And I know I'm shocking Professor Mel O'Brien by my optimism, but we'll talk about that after the session. Today we are in the midst of quite a half step back that became visible first in the 1980s and 90s as a backlash against decolonization, women's liberation, LGBTQIA+ rights, racial civil rights, and yes, international progress against genocide and other mass human rights abuses. We have even seen torture re-legalized, at least in the United States, where I'm from. We now need to drive a front lash to respond to this horrible regression with an even greater push forward than led to the backlash. While it is usual to begin a presentation by thanking the organizers, the logic of my remarks make it more appropriate that I end by thanking the Ministry of Foreign Affairs of the Republic of Armenia, the Acting Special Advisor to the UN Secretary General for the Prevention of Genocide, Global Action Against Mass Atrocity Crimes, and the International Association of Genocide Scholars for coming together to organize this crucial event. I would like to praise especially the Ministry of Foreign Affairs for its principled commitment to the struggle against genocide and related mass violence through 5 global fora. The Armenian people, themselves victims of genocide in the past and present, have created a universal program against genocide that recognizes equally all victims of the past and is equally committed to stopping genocide in every corner of our globe in the future. The most fundamental requirement for ending genocide is a truly global movement where groups across the world come together. Humankind is indebted to the Foreign Ministry for recognizing this and taking this important step to foster the global movement. It is precisely the action of commitment demonstrated through the global fora against the crime of genocide that provide an excellent model for the kind of effort and undertaking necessary if we are going to reverse the current negative trend and end the odious scourge once and for all. Thank you very much for your attention.
Thank you very much. I think you raised so many alarms, but also with that, you brought so many recommendations and so many ways to overcome these alarms. This was very important, specifically when we address situation in our world with increase of such situations. But we also need remedies. We need also recipes how to overcome the situation. Thank you so much. My last speaker is a well-known person in Armenia. Is Luis Moreno Ocampo, founder, chief prosecutor of International Criminal Court. Luis Moreno had a distinguished role as a prosecutor during the transition to the democracy in Argentina, and as the founder, chief prosecutor of the International Criminal Court. He was deputy prosecutor in the trial against military juntas in Argentina, and a film that has been made by him and about him and received a Golden Globe. As the first chief prosecutor of the new permanent International Criminal Court, Moreno had to put court into motion, establishing the structure and the Office of Strategic Policies. During his tenure, he obtained an arrest warrant for the crime of genocide against Sudan President al-Bashir. Thank you very much for all your work, and the floor is yours, Mr. Ocampo.
Thank you very much. Thank you for inviting me. For me, 2 days discussing genocide is like a party, because I spent years of my life investigating Darfur genocide, prosecuting Bashir, getting the arrest warrant for genocide. Then I went to Yazidis in 1915. Since 2023, I'm working with Armenian case. So I'm obsessed with genocide. And my friends refuse to even start to discuss it with me. So being here for 2 days, listening to you and discussing with you is an enormous privilege. Thank you. I'm delighted. You are my club. Our conversation here is really opportune. Elizabeth Prachendorf, okay? Elizabeth Prachendorf said very rightly at the beginning, in the first panel, we need to move from early indicators to action. Action is the real game. And we need to discuss how to do action. And in fact, we're in Armenia, in this beautiful place. They show us the history, how they protect it, and if we use our early indicators, you should conclude that it's an enormous risk of genocide against Armenia. I was here in September, I went to the south, I saw Azeri troops in the top of the mountains. The Center for Truth and Justice present a communication to the prosecutor of the International Criminal Court presenting the ongoing genocide here in Armenia, because Azerbaijan is already isolated and inflicting conditions to destroy the group, different little village. So our presence here is an opportunity. And for me, it's incredible that this Center for Truth and Justice communication presented, this is the first genocide where the Congress, the parliament, say that. The Azerbaijan parliament, quoted in the Center for Truth and Justice communication, said, Armenia does not exist. It's West Azerbaijan. So that's in the parliament. So the decision to remove these people is already taken by the parliament. I never saw something like that. It's a nice proof for a criminal case. So I think today you mentioned Armenia ratification to the Rome Statute is an important protective measure. There are already 5 head of states, including Putin and Netanyahu, indicted by the ICC. Aliyev knows he could be the next. So it's not everything, but it's something very important. And that's why international law could be a protection. However, international law is not the only normative system. And that is, for me, what we need to include in this conversation. That was my learning process in the ICC. See how diplomats have different protocols, how NGOs have different protocols. So this forum is an opportunity for all of us to put our mind together, to discuss how we can play together. That is the chance Armenia is giving to us. Let me summarize. I have 2 points. The Genocide Convention is different than any other international treaty because established this duty to prevent and to punish. Other international treaties just establish duties in their own country. This convention established duties in other countries. That's why using the word genocide in the prevention phase is crucial. Ethnic cleansing, atrocity crimes are graphic words, but have no legal implication. That's why I believe at this moment on the prevention time is crucially to use seriously genocide or the risk of genocide, because that triggers the duty to prevent. To help Armenia, we need to say this is a risk of genocide. To help Nagorno-Karabakh people are people from Azerbaijan. So it's not sovereignty to protect them. So the only legal protection they have is the Genocide Convention. That's why Melanie yesterday said the importance of the prosecutor of the ICC convicted for genocide. I tend to disagree. A prosecutor presents the best possible case, the case that he knows could win. I was fighting with my lawyers to move forward the genocide case. In the first case we did in Darfur, we did not charge genocide. We did crimes against humanity and war crimes. We got this arrest warrant and then we moved forward. And it was a big debate with my lawyers. And I had to appeal the case to win the genocide charges. So that's why I fully understand why the prosecutor chose in the Darfur case, in the Gaza case, a small, very clear case of starvation, because starvation is an obvious crime. Genocide is much more difficult to prove. So convictions will always rely on evidence. Instead, at the beginning, in the prevention part, we just need the risk of genocide. And the standard is reasonable based to believe, is not the certainty. So that's why I will emphasize, it's not about conviction of genocide, it's about prevention with genocide. So, there are 2 different duties, punishment and prevention. On punishment, the good news is the existence of the International Criminal Court solved the problem for state parties. State parties can just refer the situation to the ICC, and that's it. They even don't need to say it's a genocide. They just ask the prosecutor to investigate the crimes. But that is something we are not exploiting. We should exploit more this idea. We should exploit more state parties of the Rome Statute refer, for instance, the situation of Armenia to the ICC, putting pressure on Aliyev. That's something we can do. Because I saw, Matthias was talking about the role of prevention of the court. The crucial role of the court is prevention. The best outcome of the International Criminal Court is never a case there, because the national courts are doing the cases. So prevention is in the statute. The preamble says to contribute, the main task is to end impunity, to contribute to the prevention of the crimes. I think that Darfur case, how the ambassador Richard Williamson, working for the Bush president, he combined in a very nice way punishment and prevention. He convinced Bush to accept the court decision. Bush was very against the ICC, but the ambassador convinced Bush that we can be useful to push pressure to end the genocide in Darfur, and then he got the deployment of the UN peacekeepers, putting pressure on Bashir with the arrest warrant. And for me, I missed Richard Williamson. He died, sadly. But when a meeting, he said, I have 3 points. First point, I don't like the ICC. Second point, I told Ocampo not to indict Bashir. Will complicate my negotiation. Third point, when Ocampo indicted Bashir, I took advantage of it. Yes, that's what I'm missing. Diplomats who know how to combine elements. That is not just one law, always no. How to combine. Bush was, for some reason, interested to control Bashir. Okay, this law offers him an opportunity. The issue of prevention is now, today, in Armenia, very critical. lawmaking will help, but we need to push the UK, for instance, who is promoting British petroleum business in Nagorno-Karabakh, ignoring genocide. European Union, who want energy from Azerbaijan, promotes calling Aliyev a trusted partner. So Israel, a state party of the Genocide Convention, the victim of the Holocaust, victim of the jihadist attack now, is providing weapons to Azerbaijan to attack Armenia. So this is prevention. We should work on these issues. This is, for me, the work we have to do. Because we need to, early warnings are not really needed because we know there's a risk of genocide here. The issue, what need is discuss what state can do. And on this front, it's better ask for less than for too much. I started to understand genocide because I was teaching at Harvard and Samantha Power was writing her book. And was learning from her, all the system is created to do nothing. It's not the system is failing. They are happy because the system is, they invent how to manage to do nothing. So that is the consistency she described in her book, including starting with Armenian genocide in 1915 until the Kurds, until Cambodia. And then after she was in the Obama administration and she was in the Biden administration, she came to Nagorno-Karabakh and she could say nothing, showing her point. Her point is the system of the states we have to be changed. And it's possible. Sheila yesterday presented the veto power as a big problem. In my life, I saw how French ambassador took advantage that in Security Council there are 9 state parties of the Rome Statute. Then when he proposed to refer the Darfur case to the ICC, immediately he got 9 votes. In those days, Russia also was in agreement. So US had to veto a Darfur resolution. And then the ambassador of France called her. Without changing the UN rules, I don't think they will be changed. I don't think any chance to change the UN rules, but there are new dynamics, and we have to learn how to cook, how to combine them. So, let me finish. The lesson I learned in my practice at the ICC is that Genocide Convention is not the only normative system. Ambassadors have to follow rules, how to follow their own instructions. And they normally don't. I remember when I was planning to issue the arrest warrant against Bashir, a legal advisor of the big country came to my office and explained to me very clearly. He said, Luis, we are also concerned about genocide in Darfur, but my country is a country, has agenda bigger. So we have interest on oil in Sudan. We have interest on Sudan cooperation on the war on terror. We have interest in relationship with China, interest in relationship with Africa. So this is the country. So they have different interests. It's not they are against genocide. They postpone genocide. And that for us is a matter how we can transform this postponement. That is our business. Not just complain they are not doing, because they will never do it. That is Samantha Power's lesson learned in her book and in her life. Let me finish. I believe that I'm working in Sao Paulo University. I left Harvard because they don't care a lot about. So I am in Sao Paulo University in Brazil, working in the global order project that includes a genocide. And we are focusing on the 2 issues we identify. One, what are the rules? Evelina Oshab described very well that UK and Australia, the rule is to prevent genocide, we need to wait for a court decision. I discussed it with the Australian ambassador, say, Ambassador, if you wait for a court decision, it's late, already happened. It's ridiculous. Well, it's our protocol. So the plan we have is to collect all these rules, what Germany rules are, what UK rules are, Australia, all the world, and put together to understand, okay, expose them, expose how they are normatively postponing genocide. And the next thing is identify who are decision makers. Elizabeth Prachmendorf, okay, say that her organization is doing a mapping exercise. That is extremely interesting. I love to have an IT system, like a Facebook system, where you push a button and appear who in UK is deciding to ignore Nagorno-Karabakh, who in UK is connecting British Petroleum with Azerbaijan, and then we can talk specifically to him. So it's not just about the rules, it's about the other rules and who are the decision makers. That is, for me, what we can do. And I believe we here, if we combine our minds and we understand each other, we can be a very important tool. And I'm delighted to be in Armenia, not just because you are obsessed like me on genocide, but because Armenia has an incredible tool. I learned that I participated in a campaign on COP29 with Armenians from all over the world, and there were 6,500 Armenian activists, and the point is from 120 countries. So Armenia is the army of activists we need to fight not just against genocide in Armenia, to fight for genocide against in Darfur, in Ethiopia, in Rohingya, everywhere. Armenia is willing and ready to help us to fight for civilization. That is our job, and I'm very glad that you invited me to be here, and the work now is to start to do it again. Thank you very much.
Thank you so much, Mr. Ocampo. You are absolutely right. Armenia is working for civilization.
Yes.
This is critically important. Being a small country, it raises issues on international arena. These are very important for the entire world. I would like to thank all the panelists and give applause to everyone. This was critically interesting. But we didn't finish with that. A final document. What recommendations each of you would give to this conference in order to have final document? Just 1-2 minutes of your deliberation and proposals. Yeah? You want to ask questions? Maybe we will have recommendations and then questions. Okay, thank you.
Do we send by email?
No, you got to say it
now. Now? Okay. Do the punishment and prevention, action, understand how to do action, and then we need to understand the rules of different countries to prevent, and who are decision makers.
I tried to address that in the remarks, but I would say more than anything else, we have to be willing to question things that we really don't like to question, that we're uncomfortable questioning. I liked what Sheila had to say about the Noam Chomsky quote. Was very interesting, but Noam Chomsky is a great case study of the problem of genocide prevention.
Recommendation, philosopher, recommendation.
No, so he's someone who has denied multiple genocides and chooses which genocides to take on based on his own political agenda, and that's very common. So what do we need to do? We need to challenge that kind of thinking, and I think, following what you said, we need to dig deeply into the very nature of the international system of states. We need to dig deeply into what law is and what it's supposed to do. I try to suggest that we need to rethink our way of talking about reality and the connection between what we say and what's really happening and so forth. So I would say we need to push a lot of deep things, and we're generally uncomfortable doing that. We like to stay within very, very, very easy bounds and say the same things over and over and complain about the same things. But if we really want progress, it's going to take incredibly challenging efforts at getting at some of the deepest aspects of human civilization, if I can say it that way.
Thank you. A few things, I think. First, I would maybe recommend to contextualize the prevention of genocide in a framework of prevention of use of force, no use of force, and threat to use force, because that's an important mention. Also, not only to focus only on genocide, but also crimes against humanity, and link it with strengthening peace or preventing the war, preventing aggression, I would say.
support and strengthen the salience of international law in addressing the challenges that we're speaking about here, genocide and other, the most serious international crimes, by identifying the other threads that we can bring to the table together with the legal thread and create that web of effective enforcement.
Thank you.
Well, first of all, to earn my salary, I think I should advocate for calling upon more states to join the Rome Statute, and also call for full support and cooperation of states with the ICC. And then perhaps on a more sort of personal and academic note, I would really like to see further and continued research on how accountability mechanisms and how accountability efforts influence the thinking of potential perpetrators, and also go deeper into this by way of looking how whether it differently influences different types of perpetrators, such as government actors, rebel actors, and there may be other categories as well. And also whether there's a different, when it comes to different types of crimes. I mean, in the broader family of core international crimes, whether there are differences in how accountability may deter perpetrators from committing different types of crimes. There were already some allusions to this, I think, during this conference. So this is, of course, a long-term project. And also because the research so far has understandably focused on, well, when it comes to the ICC, and of course the ICC is only one piece of the puzzle. I mean, we didn't have time to talk about complementarity and the crucial importance of national action for accountability. But also the ICC's work has expanded so much in the last 5, 6, 7 years that it will be very interesting to see how that increased scope of the ICC's work will impact the field of deterrence.
Thank you very much. I just wanted to make one have a reaction to the quote Mr. Proview made from a professor, I don't know, who suggests, as you say, provocatively, that the convention has the potential to trigger more genocide. I think it's nonsensical, it's meaningless. In the same way you can argue that the International Covenant on Civil and Political Rights triggers more violations of civil and political rights, which are violated massively and systematically all around the world. And the question I have also is to Mr. Hellman. Fact is that between half and 2/3 of global population are not covered by the ICC jurisdiction. And not just that. Great powers are not covered, from the United States to Russia to China, as much as to Pakistan and India, Indonesia, Turkey, Israel, and the list goes on. In political and practical terms, how would you, how do you cope with that challenge? Thank you.
Okay, maybe you were first and then Rebecca. Yeah, please. Please, it's you. Yeah. You do not have microphone.
Thanks, Madam Moderator. I'm Mahmoud Zaybak. I'm a war correspondent and a human rights activist. I want to ask about personal wound related to what you are talking here. As you know, a few days ago, the dictator has fallen in Syria, and me and my family was looking for a brother in those days who was a victim of enforced disappearance for 12 years. And we had a hope that he's still alive because one of my friends found his mother alive after 8 years of thinking she's dead under torturing in the prison. So now, while as people looking for more secret prisons there in Syria, nobody know that we call it secret prisons because it's one way. When you go, you never come back to tell where it is. So as people looking for those prisons, and I'm one of them with my family, as we are looking, I want to ask Mr. Ocampo and Mr. Hillman, is there a mechanism for immediate accounting and questioning for those criminals? Because while we are looking and searching, the leader of jailers and kidnappers are there in another dictator lab in Russia having safe haven.
Yes, Mr. Ocampo, you're right. The Armenian people gave so crucial knowledge to people, to world, to humanity, and I think this global forum is an evidence of that. But my question is for Professor Henri Thériault, and excellent lecture, and also for the other panelists. If it's a large and philosophical question. You are right about the fact that that the mechanism of dehumanization is so crucial, important for inside the genocidal process and the paroxysmal stage of a genocide. If we consider the law, if we consider justice, if we consider verdict of trials, as a response to the genocide, to the crime of genocide, how is it possible to present and to make law, justice, verdict as a mechanism as a commitment of rehumanization, as a rehumanization mechanism, if it's possible?
Thank you very much. My question maybe flows from Mr. Kirikosian's closing remarks with regards to crimes against humanity, but could certainly be answered by any of the expert panelists. In Gulnara's opening remarks, we looked at the discussion of lacunae in international law. And as we're well aware, we have the Genocide Convention, we have the Geneva Conventions and their optional protocols with regards to war crimes. And crimes against humanity are obviously among the core crimes contemplated by the Rome Statute, but the Rome Statute only reaches individual criminal responsibility and not state responsibility. And so I'm wondering if any of the panelists have views on the decision just a couple of weeks ago by the Sixth Committee to refer the crimes against humanity draft articles to the treaty negotiation stage in 2025, 5 years after the International Law Commission drafted them and many years of advocacy later. And as a follow-up to that, are there specific elements of the draft articles or of the crimes against humanity as articulated in the Rome Statute that should not be diluted or that could be enhanced in such a treaty? Thank you.
Shall we answer this round of questions and then go on if there are any? We can take these questions. There were some direct questions to you and to yeah.
Thank you. I would like to answer the question from Mr. Natsakanyan, if I'm correct, on why great powers have not joined the ICC and how do we cope with that. Well, first I would say that when the ICC was created, when the Rome Statute was drafted, in a way the big question was, how strong do you make the ICC? In a way, you had to find a good balance, because if you created a very, very strong independent court that could basically do whatever it wants wherever around the world, very few states would have been willing to join it. So a number of checks and balances were put there to kind of give states some kind of a role in the system, also give the UN Security Council some kind of role as a recognition of its crucial role under the UN Charter. On the other hand, some people say, well, it should have been made in such a way that, all countries would become part of it. Well, of course, one could have created a much weaker court, and some states advocated for that, a court where states would have basically a veto right on any investigation, any case, where basically states would be controlling the court, including its prosecutorial and investigative and judicial actions. Well, would such a court be worth creating? So a compromise was found. And it was, in many ways, the IC has been a project of small and medium-sized states, those states who really need the protection of international law, whereas many big and powerful countries feel that they don't need that because they have military power, economic power. It's quite remarkable, I think, that 125 states have now joined the system, and it's slowly getting bigger and stronger. This is the way it is, and I don't see, in a way, a good alternative to how we have come about, reaching this point. Now, how do we cope with the fact that many of these powerful countries are not part of the system? Well, yeah, we have to be able to count on the firm commitment and full cooperation of the existing states parties. And by and large, of course, that cooperation is there, and it has allowed the IC to do a lot. I mean, look at the number of cases. I was just going through the number of, well, of course, many arrest warrants have not been executed, but they're there. The court has gone to so many situations, investigated so much, raised so many cases. So I think we have achieved a lot despite the obstacle of 1/3 of the world's countries not yet being part of the system. On the question from Mr. Mahmoud, sorry, I don't know your last name, on Syria, I can't really comment on that because in Syria the ICC does not have a jurisdiction because it's not a state party. So I'll leave that for others to answer. Thank you.
Let me complement. I can be less politically correct because I'm not there. In Syria, the ICC still is not a state party because they never would like to be a state party because we can investigate Assad. And why the UN Security Council will never send the Syria case, at least for the past, because US and Russia were involved there. So they don't like the ICC investigating them. That's why they invented this mechanism to collect evidence, but there's no real court. So that is geopolitical, and that's the answer to your question, the same. So with a court that just rely on big powers, will be never justice, because Russia will protect Syria, US protects Israel, they protect themselves, and then there is no justice. Now, they created this court with an independent prosecutor, and of course now we have a problem because they indict Putin, indict Netanyahu, everyone is happy and unhappy at the same time. But that way, it's a court to protect small countries. It's not a tool of powerful countries. And the miracle, to finish something like that, is I was at Harvard teaching when they offered me the job with SEC. And one of my colleagues told me, Luis, it's a great honor. You have to reject the case, the position. Why? How can you reject the position? And he said, because without the US, you never could carry out an investigation. You never could arrest persons. So you will be 9 years in The Hague doing nothing. That was his forecast. But today you see the court without Russia, without US, without China, without India, did a lot. And it became a main center of international criminal justice. So that's why it's better for the court not to have the big guys on board. It's a project for the small countries.
Thank you for that very deeply probing question. And I would just say that at the start, we have to recognize that criminal justice is not a great model for understanding genocide. With all due respect, there's an important role for that. But genocide at once is not an individual action. It only happens when groups commit joint acts in very complicated interrelationships. And what we see with prosecutions, very rightly so, is we target individuals within those structures, but that doesn't mean we get at the structures themselves. The second thing is, genocide is a crime, I grant that, but it's a lot more than a crime. It really fundamentally reshapes the social reality, and often the physical reality, the geographic reality of the world as a whole. Lemkin saw it that way, right? That a destruction of a group changed human culture and society fundamentally. And so in that case, we need to think more broadly. So first of all, you mentioned rehabilitation. We need to be thinking about perpetrator groups as a whole. Obviously, a criminal justice model punishing a group, we know historically that hasn't worked very well, right? But it's also, I think, ethically wrong, because in any perpetrator group, you have people who are fighting actively against the genocide that's taking place, who are coerced in different ways into a kind of complicity that's not volitional, and so forth. That's where the model of rehabilitation, of trying to figure out how to transform a society that was genocidal and actually embedded the genocidality even more deeply through committing genocide, through really reconstructing itself as a state around genocide, becomes really important. But also, I'm a big advocate of reparative justice as opposed to criminal justice. I mean, not as opposed to criminal justice, but in addition to criminal justice in cases of genocide, because really the goal of justice needs to be to do as much as we can to reestablish the viability of the survivor group. That's really what this is about. And there are many ways to do that. One of them, very simply, is to make perpetrator groups responsible for the future survival of the victim groups that they have fundamentally weakened and made vulnerable to renewed violence by them or other people. Think of it this way. What if Turkey had been been pushed or had chosen to offer reparations for the Armenian genocide that included security guarantees to Armenia, so that when Azerbaijan was considering or beginning its attack in 2020, Turkish weapons and personnel were not used to help in that attack, but were actually required by a reparations agreement to protect Armenia. Now, this is obviously, we could spend days thinking that through because there are so many complexities, but that would change so much about the post-genocide victim situation that I think we really need to look at. So you asked for philosophy, I guess you got it.
And if I can just respond to Mr. Natsakanyan's observation, I shared your reaction. But insofar as this panel was designed to speak about gaps and challenges, when I read this article, especially from somebody who has played such a prominent role in both the study and the practice of international law in these spheres, it seemed to me striking. I don't agree with it, but it's a striking observation.
Criminal trials are important ritual beyond the criminal law. It's a different, it's where the community are together, where the killer could be with the victim, and what there will be definition of what is right and what is wrong. So it's much more than sending people to jail. It's a very important communication ritual. That's why it's not one or the other. And it's the only thing we have, okay? It's the best thing we have. So
100% agree, and that's what I was saying. I'm not saying get rid of that process, but we need to expand in some new areas as well, I would say.
I think we exceeded our time, but we can take only one question if there is any. No? Yeah, thank you.
I think there was one question by, I think, Rebecca, about the draft articles on the punishment and prevention of crimes against humanity, which is now moving forward. I think it's really, I'm very happy to see that it's moving forward. And if the question was whether that would dilute the applicability of the ICC statute or somehow get into, my understanding is that the genocide and the crimes against humanity, we really need also to have this convention which is clearly creating this institution for state responsibility also, because that's my feeling that is lacking now. Because for the genocide, yeah, if you can clarify, it would be great. Because that's what I got.
Thank you for the opportunity to clarify. No, that was not my intentions. We're very supportive. I have my bangle here about the Crimes Against Humanity Treaty. I don't think in any way it would dilute the Rome Statute. My question was whether during the negotiation process, as states try to perhaps take away from what the International Law Commission has drafted, if there are particular areas that we should be on the lookout for that are vulnerable.
If I may, I think the risk in 2025, the state's idea to support a strong convention, I don't see the will. It's complicated. So there will be, maybe they dilute the crime. That is the danger. The danger is not how to improve. The danger is how to avoid a dilution of the crime. They could request, in Nuremberg, crimes against humanity required a war. They could go back to this idea. So you have to be careful of that, if you can.
Yeah, okay. Last question.
Thank you for inviting me actually to attend this very instructful conference. My name is Kabur Ganna and I'm from Ethiopia, actually. I learned that Ethiopia is a country that is not really a member of the ICC and also has not signed actually the Rome Statute. And we are today on the 4th year of what many people in Ethiopia call genocide or crime against humanity going on in Ethiopia by a prime minister, as you all know, who is a recipient of the Nobel Peace Prize. The issue today for many Ethiopians is that in a country where you have perhaps the second or the third diplomatic presence, where you have major UN institutions, that said things actually go on. The early warning system doesn't seem to have worked, and the war still continues. And in terms of figures, I don't know whether that's the right figure or not. The newspapers claim something like 1 million people have perished actually in that war. And so I wanted to hear, so what do the international community say when such crimes actually today is going on with drones, with military aircraft, with soldiers actually going day in, day out actually killing youngsters in these regions, so specific regions actually. Before was a Tigray region, now it is an Amhara region and partly the Oromia region. Thank you.
I think Armenia should help you. I think one of the plans we have with Armenia is to do massive campaign, not just for the Armenian victims, for Ethiopian victims, for Darfur victims, Rohingya victims. So we need to engage and demand, because as you are right, institutional IC cannot intervene, but citizens can talk about this issue and highlight it, because in the Nagorno-Karabakh crime, it disappeared from the media. Tigray are not existing. So we need to at least provide visibility to the problem. So you can discuss later how to do that.
So thank you so much, and I want you to applaud again to all our panelists, excellent panelists. And with this, we conclude our panel. Thank you.
Friends, if I may ask you to remain seated. Excellencies, dear colleagues and friends, as we're approaching the concluding segment of our two-day conference, it is my honor to provide the floor to His Excellency Mr. Vahan Kostanyan, Deputy Foreign Minister of Armenia, for chair's summary. Thank you.
Thank you very much, dear colleagues. Good afternoon. Let me thank again everyone who took part in the Global Forum, and to thank for very interesting discussions, to thank our moderators who were kind enough to help us to organize this event. Let me remind you that this year's topic of the Global Forum was on early warning and early action mechanism, and I do believe that we had impressive and in-depth discussions regarding two topics. So, dear colleagues, let me share the summary which was prepared by the team of ministry regarding the panels, interesting panels that we had during these 2 days. So yesterday, at the plenary session, we first looked at the role of small states in prevention agenda against the background of evolving risk factors, debating the complex nature of genocide prevention that should be perceived first as peace and security challenge. There is shared understanding that the action and policies against minority groups and aggregated forms of hate speech and hate crimes must certainly ring the alarm. We have also discussed the cases where small, like-minded states unite and take a leadership to reform both the instruments for mutual legal cooperation and advocate for revisiting the existing bodies, who bear preliminary responsibility for maintenance of peace and security globally. Among our deliberations, the issue of a veto in the UN Security Council popped up. Panelists looked at the crucial issue of the threshold and the instances when it is exclusively tied to court verdicts, stressing that in some cases it may undermine prevention. The first panel was dedicated to the development of UN early warning mechanisms. Here we tried to examine the process of evolution, taking the work of Lemkin and the adoption of landmark convention as a starting point and evaluating the impact of documents and policies in decades that followed. Despite the fundamental role that the documents and policies in decades played, now we see that in some cases there are early warning factors which are not taken into account. Emphasis were made to the issues of states' responsibilities, documentation, independent research, as well as fight against denialism. Panelists noted that the issues of protection of minorities should feature more prominently across the international agenda, especially when dealing with vast political interests of states concerned. During the second panel, we have looked at the role of various stakeholders and the synergy between them. Panelists stressed the issues of accountability for use of force, noting that international law prescribes strict limitations, but tragically, those binding obligations are violated in increasingly alarming scale. The issues around decreasing UN involvement and increasing number of conflicts was also elaborated. The examples of policy documents were discussed, stressing the framework analysis of risk factors may serve as a guiding document, but time and time again we confront the issues of enforcement and bringing perpetrators to justice. Both as an emerging challenge and as a tool for prevention, detection and fact-finding has an important role, also using the new technologies, social media and artificial intelligence. During the third panel, we continued to look at the risk factors and preventive measures. Here the issues around humanitarian law and humanitarian cooperation were stressed. Crimes against humanity, their prevention and overcoming the consequences are a multifaceted and challenging task that entails dealing with issues like missing persons, denial of humanitarian access and lack of political will to invest any effort on reconciliation. We have also discussed the role of parliaments as well as regional organizations that must serve as a fora for ensuring the states uphold their commitments and are ready to engage in dialogue. Fourth panel was focused on the role of courts as fundamentally important actors at all stages of prevention and accountability process. The Rome Statute and the work of International Criminal Court as a body specifically designed to address the violations of international criminal were elaborated, exploring the link between peace and justice. The speakers on fifth panel discussed the multiple societal actors such as civil society and faith-based organizations can both amplify their voices for preventing crimes like destruction of cultural heritage. Our panelists draw distinctive links between the rule of law domestically and commitment to ensure it globally. The clear pattern of more and more states, in particular small states, applying to the courts, including the ICJ, as an instance of last resort to avoid chaos in international system. Dear colleagues, if you allow me also to share my impressions from 2 days' discussions, probably if I try to remember what was the word which was used the most during these 2 days, that will be political will. And the discussions were tackling different layers and levels of political will and from different aspects. We were talking about the political will on national level, on regional level, but also international. And we're talking about how we can affect the political level, political decisions, again, on both 3 levels, on national, regional, and international. I do believe that despite of all challenges that we are facing, and despite of all the precedents that we see, and despite of the fact that there are not that much of success stories when there was enough political will to prevent the genocides, we need to continue our work on this direction. This is the dedication that Armenia has, and we'll be going to work with all our partners, with like-minded partners, to build the coalitions to prevent the genocides.
because, as it was mentioned during one of the panels, we are the international community, and we are the ones who should apply the international law. I thank you very much, everyone, for being here with us during these last 2 days. But let me also ask everyone to give a big applause to a team of Ministry of Foreign Affairs. And here we have people who are working in this direction on genocide prevention, on human rights protection, despite all the challenges that the international community faces and despite all the challenges that Armenia has been facing during the last couple of years. Let me specifically ask once again to applaud the mastermind of this event, Karne Sujan, who is the head of department. Thank you very much for your dedication and for your work. And thanks everyone for coming here. Last but not least, if I may ask you to applaud 2 young diplomats who were working the whole day and night to make this event happen, Shoger and Albina. Thank you very much for all the work that you did. Thank you. This is the 5th Global Forum. We'll have the 6th for sure, because fight for the human rights and for the genocide prevention never stops. Thanks.
Dear friends, if I may, last 2 announcements, if I may ask the distinguished panelists and moderators to come to the podium for a family photo. And the very last announcement today at 7 o'clock, we're inviting everyone to the concert dedicated to 76th anniversary of the adoption of the Convention on Prevention and Punishment of Crime of Genocide. It will be in the National Center for Chamber Music after Komitas, so we will be waiting you all there. Thank you.